Yes, item number 41 is a contempt matter. Personal appearance was ordered. I am for the petitioner, my lord. It has been complied with, my lord.
I am the sole respondent, my lord. Payment has been made. Item 41, my lord.
But what about the respondent? Has he come or not?
I am the sole respondent.
No, there is a
He has,
personal appearance.
he has to be produced by the Superintendent of Police CM Vigilance Cell because he is under judicial custody, my lord.
He was arrested, my lord.
He was arrested in connection with some different case. Payment has
But
been
otherwise it has been complied.
It has been
complied. Complied,
We will close this.
my lord.
Otherwise you would have insisted his appearance. Since there is a judicial order.
He is in custody, my lord.
He is in judicial custody.
This court, by order, it has directed personal appearance of the sole respondent against whom there is allegation of contempt. This, this court, however, has been apprised that the sole respondent is in judicial custody in connection with some police case, in connection with some criminal case lodged by the Vigilance Department. However, the speech of Chakraborty, the counsel for the petitioner, has submitted that the order in question has been complied with. Also heard P.A.K. Barua, Senate counsel representing the sole respondent to submit that the appearance of the respondent was to be done through the concerned police department as he is under so, considering the aforesaid facts and circumstances, this court is of the opinion that interest of justice is served if the interest of is of the opinion that since the order in question has been complied with, there is no fruitful purpose served to keep this contemplation pending. More so when the sole respondent is in judicial custody. Accordingly, contemplation stands closed.
All right. Compliance report may be kept in the record if necessary.
You with sole respondent who has also placed for this court a compliance report dated.
Dated, my lord. Payment was done, my lord. On
Dated your
28/8, my lord.
28/8/2023, as per which, it appears that payments were done on
28/8/2023.
payments have been done. As per a copy of communication dated 28/8/2023 is made part of the record.
Public. DPO.
Order to outside. Yes.
Lordship, I beg to mention for listing of a writ petition in motion column on Friday, Lordship.
Have you filed or not?
Yes, Lord. Apply.
May I pleasure, item number 26.
Yes.
Maybe taken any other day, my lord. Other day.
26.
Yeah, for some personal reason there. 26. Other side is government.
Veterinary department.
Yes.
Have you informed or not?
No, we have not the government. my lord.
No, not vet. They have a special council. This animal has to be in veterinary.
Yeah, I will inform, my lord. I will inform. I will
You get the inform them. Will accommodate. Not now.
Yes.
May I please your
I
lordship?
am Kotoki.
May I please your lordship? Item number
I think you can inform Ms.
Yes,
Gayan also. Gayan. Gayan is the third. Gayan. Yes, madam.
item number 34, lordship. Respondent number 5 filed their affidavit in opposition. Today
Yes.
we are going to file our reply, lordship.
Okay.
This matter may come up next week, lordship.
35.
34.
Okay.
Mia Chandali.
MS Kanungo, Senate Council submits that a rejoinder affidavit is being filed today.
Going to file. We are going.
Is being filed today. List of affidavit along with such rejoinder.
Deeply.
May I pay, lordship? But may I pay for listing?
There is no interim order, madam. Yes.
May I pay, lordship? Lordship, may I pay for listing of this writ petition tomorrow for motion, lordship?
Motion.
Motion, lord.
Urgency is there.
Lordship, the urgency is that by day after tomorrow, the last date for submission of my written statement will be over. I had sought for certain documents, nothing was given to me.
Writ petition.
Lordship,
Writ petition.
writ petition, lordship.
Why?
Lordship, we are challenging the action on the part of the respondents in trying to continue with the disciplinary proceeding without giving us
Oh, in a DP.
in a DP.
You said written statement of defense.
In a written statement.
Written defense.
The last date will be
What
day
is the
after
issue?
tomorrow. Lordship, the petitioner was placed under suspension and thereafter a show cause was given to him. Now, Lordship, on receipt of the show cause, we had filed the representation saying that we want to inspect the document.
Yes.
Document inspection was allowed, but the relevant files were not given to us. Neither were we allowed to take extract of the relevant document. We wrote a letter to them on that day itself, on day of inspection, saying that please furnish us the copies, then only we'll be able to file our written statement of defense. That was not done. As per the show cause, we were to submit our reply within 10 days from the date of receipt of the show cause. As the 10th day
If they have
was,
not given documents, you file without documents, without
Lordship, we have
prejudice.
also challenged the suspension order, Lordship.
Suspension is a part of the challenge.
We were also kept under suspension, though
You file your written statement. What is the difficulty? If
Lordship, the
this,
difficulty is that
this will be a ground of challenge in the GP.
I understand, Lordship.
Why are you filling up giving them a chance to fill up the lacuna? If you feel that documents have not been given to you, inspection was allowed, you have said.
Inspection was allowed, Lordship, but relevant files were also not given to us. And the
So how did you get the inspection done?
Lordship, the one guard file was given. From the guard file, we could find out that there were certain other files which would be relevant. And the matter pertains to the time when he was deputed
When
in
do
the
you want?
AFDC.
When do you want?
Lordship.
Tomorrow.
Obliged, Lordship.
But we are doubtful whether we can grant you any relief.
Good morning, my lord. I beg to mention the WPC 5399/2018. Kindly list the matter after 1 week, my lord. It's a promotion matter.
Okay, next week.
Thank you, my lord.
May I beg to mention for listing, my lord, on 7th, my lord.
What matter?
Upon selection and appointment of Gao Pradhan, my lord.
The matter of which year?
This year, my lord. There was a stay, but it was already vacated. The matter was supposed to list on 3rd week
Next week.
of July.
It is your lordship. Lordship, in item number 30 of today's list, your lordship, we
Yes.
have filed an affidavit in reply, your lordship.
Yes.
That may kindly be called for your lordship.
May it please your lordship. Lordship, I beg to mention a 2015 matter which has come up before your lordship on 25th of July for hearing. After 2 weeks, it was listed and not come up, my lord. Any day
Bench
next
3
week,
matter.
My
Bench
lord.
3 matter.
my lord. Bench 3 matter, my lord.
15 matter. When do you want? Next week?
My lord, next week, any day, lordship may give a date, my lord.
Yes.
Please, your lordship, I beg to mention item number 23, lordship,
Yes.
which concern of the other side, lordship. Kindly matter be adjourned for the day, lordship.
You are mentioning on behalf of whom?
And Burwa, lordship.
And Barua. PhD has been informed
Yes, lordship. Both are government also informed.
on a prayer made on behalf of the petition. Matter is adjourned for a week. Yes.
Actually, this is also. My lord, matter relate to my selection and appointment, my lord. I am praying for listing on next
Motion matter.
admission, my lord.
Which year?
2019, my lord.
Okay, next week.
Please, your lordship, I beg to mention you for a listing of a read petition. It is
What is the stage?
regarding the appointment of
No, what is the stage of the petition? Motion matter.
admission,
Admission. Case of which year?
2023.
Ministry. No, not. What is the urgency?
Regarding the appointment of the petitioner in the establishment of district court.
You have it, not next week, thereafter. Next week, there are hardly 2 working days. You have it on a date starting from 11th of September.
11.
Please, your lordship. Lordship, I beg for listing a matter, lordship. It's a long pending matter, 2013 matter.
Bench 3 matter.
Yes, lordship.
What is
Measure
the
punishment, lordship.
Huh?
Measure punishment.
Next week?
7. Okay, obliged.
Lordship, may I pray for listing of one matter in the next week, any date convenient to this court?
Next week, only 2 days are working.
Next week.
What is the matter about?
Lordship, the petitioner was granted voluntary retirement way back in 2012, and while he was taking steps for his pensionary benefits, this was not allowed to her. Then a TP was initiated. So
Now, what are you challenging?
the impugned order, by which the TP has been initiated after such a long period of time, because voluntary retirement was granted on 2012, Lordship,
And
the
DP initiated when?
2023.
23. When do you want?
Any date convenient to the court.
Have it on the week starting from 11th of September. Next week, there is hardly 2 work.
Yes, Lordship, 7th and 8th. DP.
Mr. Goswami, we'll have this at 2 o'clock because this courts are rising early because of the reference. We'll pass the judgment at 2 o'clock, liquidate the judgment at 2 o'clock. Is that Chaudhary? Because there are a number of motions. We don't waste the time now. Yes. Why 23 matter is on the top of the list?
May I please, Your Lordship?
Why 23 matter is on the top of the list under this column? Why?
My Lord, I think it's coming for about last 4 occasions on top of the list. I think
You have got the information.
they have filed the affidavit.
You filed the affidavit. You like to file reply or what?
No, not required.
Not required.
It's a question of law.
Notice has been issued already.
Yes, yes.
We can have it for admission hearing. Or you want to have the rule issued?
No.
You want the rule to be issued or you want to admission
No,
hearing?
no, it can be in one stroke, it can be decided.
Admission hearing it can be disposed,
Yes,
can be
madam.
disposed of.
Yes, madam.
When do you propose? Today?
Why not any day? I
Any
still
day?
not-
Any
no.
day is today is all of the any day.
No,
Any
what
day is
I-
not today. Any day is not today.
other than today.
Any day other than today.
Yes.
You have to qualify. Yes, tell us when.
Well,
Fix a date. This is
I'm ready, my lord. I'm
top of the-
ready.
Top of the list, man.
Yes.
We'll have it on 12th of September. Is it okay?
Yes, my lord.
Yes, my lord.
My lord, only thing the endeavor for the final
No,
disposal.
top of the list. Heard the Abed is Senate count for the petition. Also heard the NJ Khatanier, Senate Standing Council, Secondary Education Department, who submits that the affidavit in opposition has been filed on 16/8/2023. Full stop. Para, the parties are in agreement that the matter can be taken up for final disposal at the admission stage. Full stop. Para, as agreed to by the parties and considering that the matter has been listed under the column inverted comma top of the list, list this case for admission hearing on 12th
Or 14 or 14.
14th Thursday.
Yes.
14th.
Obliged.
9.
Deeply obliged, my lord.
Okay. Yes, Mr. Sharma,
Lordship,
what is-
last occasion, Honorable Court directed to produce judgment to support my case. But unfortunately, my lord, I could not find out any judgment, but I obtained one instruction, government instruction, my lord. As per this instruction, my lord, 2016 instruction was, my lord, so far as the grade 4 post is concerned, my lord, they cannot hold interview, my lord. So at this instance, my lord, I would like to enter this writ petition with liberty to file fresh
you
one.
file you want to withdraw this?
For additional affidavit, so I can bring it, my
It
lord.
is up to you.
Then, my lord, I may be allowed to file additional affidavit to bring this notification, my lord.
Yes, Mr. Chakraborty.
I am
Shri B.K. Sharma, Senate Counsel for the petitioner submits that there are certain relevant documents which are required to be placed on record, for which he prays for Alibat file additional affidavit. Also had case of proportion state council.
1 to 5.
State council. Sir, let such liberty estate is granted to file additional affidavit, which may be done within a period of 2 weeks.
My lord, date may be fixed, my lord, otherwise.
It's a motion matter. It comes
Oh,
2
no,
weeks.
My lord, item 3 to 7, my lord, all relates to, my lord, discharge from service from Assam Rifles on the ground that they had earned 4 rating entries, my lord.
They had
Earned 4 rating entries, my lord.
read,
My lord, at this stage, I'm paying for notice only, my lord.
this needs to be examined. We'll admit this.
My lord,
Admit this.
my lord.
I'm appearing in item number 3.
Your name is a dangerous name.
My lord.
Luckily, you don't have the surname. Hard. B. Pathak, when it comes to same order. When it comes to for the petition who has put to challenge a discharge order, all same date.
No, my lord, all separate petitions, my lord, all
discharge
separate cause
order,
of action.
dated kind of
The issue is same. However.
dated so and so. On the ground, what is the ground?
My lord, the discharge order was firstly not communicated, my lord, and the reasons have been only known to us now, my lord.
Where? By
In reply to our legal notice, my lord.
discharge order dated so and so, which however was not communicated. It is the case of the petitioner that only in a only when when a reply was furnished to the legal notice, the petitioner would come to learn that such discharge order was on the ground that there were red ink entries in his service record.
My lord.
Full stop. Sarah. Issue rule returnable by 6 weeks. MS RDP Tennessee accept note on behalf of all the respondents.
In 4, 5, and 6.
4, 5. I am only for 3.
Three down on 4, 5. Only date of that extra copy of the written out of the learned thesis by tomorrow.
Deeply obliged.
This discharge was never communicated to you.
My lord, the order was not given in 2 cases, my lord, orders were not given. And the reasons were ascribed to us, my lord, only after legal notice.
Other cases, which 2 cases orders were not?
My lord, item 3 and item 6, my lord.
Only first order to 3 and 6 no legal notice of the 4 and 5 we have got the discharge order.
We got, but the reasons were, my lord, as shown to us only thereafter in reply to
Doesn't
the
matter.
legal notice.
But that will be a wrong statement if we say that you have
My
not
lord,
been. 3 and 6 we have got.
my lord. 3 and 6 we did not get.
Or 3 and
4
6 you
and,
did not.
4 and 5 we got.
And Mr. Chakraborty for 4, 5 and 6.
4, 5 and 6.
RDB 3.
4,
Yes,
5,
take step by tomorrow.
my lord. Deeply.
Yes, what is this?
May I please, your lordship, in this case, your lordship, the petitioner's father, your lordship, while in service, your lordship, he died on 22/5/2005, your lordship. Thereafter, the petitioner being eligible, your lordship, applied for appointment, your lordship, under compassionate ground, your lordship.
When did you apply?
Your lordship, on 18/6/2005, your lordship.
No, that was the, when was the death? 22/5.
Yes, your lordship. 18 died on your lordship
22/5.
22/5/2005.
You applied on 18/6.
18/6/2005, your lordship. Thereafter, your lordship, after not getting any response, your lordship, the petitioner approached before this honorable court, your lordship, by WPC 5158 of 2010, your lordship. And that was disposed by this honorable court, your lordship. The order is at Annexure 1, page number 30.
Thereafter, but it appears that your matter was taken up by the DLC in 2009.
9, your lordship. But I was not communicated about that, your lordship. Again, my matter was submitted in DLC 2015, your lordship.
That which has occurred about 2 decades back.
Actually, your
What is
lordship,
the objective?
right now I have come to know, your lordship, after filing an RTI, your lordship, on 3/7/2023.
Council, what is the objective of having a of the scheme of compassionate appointment? To give immediate succor, immediate relief. After 2 decades, almost.
Your lordship, that was not communicated to me. Right now, on 3/7/2023, after filing of RTI, your lordship, I came to know.
What is your name?
S. Paul, your lordship.
Third to S. Paul, counsel for the petitioner, who by means of petition is aggrieved by the rejection of his case for compassionate appointment. It is the case of the petition that his father, Norris Sir, who was working as LDA in the establishment of superintending engineer, PW, NH Circle, Nalbari, had died in harness on 22/5/2005, and according the petitioner had submitted application for appointment on compassionate grounds. The petitioner has further stated that since no communication was received regarding any such consideration, he had earlier filed a writ petition. However, the impugned order dated. However, by the impugned minute of the DLC Nalbari in the meeting held on 24/3/2015 has rejected the case of the petition that on an earlier occasion, the DL had made such rejection, which was on 2/12/2009. It's the case of the petitioner that the earlier order of rejection was never communicated with. Issue note. Returnable. So you are 44 years.
Yes, your lordship.
Now, the delay and lessons is here.
44 years.
44
you,
years.
you belong to some.
Otherwise eligible.
You are unreserved category or what? You belong to reserved category. What is the age limit?
General category.
Huh?
General category.
General category 44. Issue notice returnable by 4 weeks. We should be the learned additional senior government some access notice on behalf of number 1,
3 and 5.
1, 3 and 5, whereas MS S Sharma, learned standing council, PW access notice on behalf of respondent. We should be the learned chief council, however, submit that the age of the petitioner as revealed from the affidavit is 44 years, and the petitioner being an unreserved and the petitioner belonging to the unreserved category, no fruitful purpose would be served by filing of the petition. Therefore, the respect considered at the appropriate stage. Extra copies. Extra copies by tomorrow. Both madam and
The petitioner had participated in a selection process in the year 2018. And
20.
When
Selection
2018,
for what
my lord,
post?
the post of constables in the CAPF.
Okay.
But when he was denied the appointment on the ground that he had availed relaxation in height and chest and would not be entitled to the OBC category reservation, we had approached this honorable court. This honorable court held that if he had not availed any other relaxation and he was within the height and chest for the state of Assam, he should be allowed to be a general candidate for the state of Assam. Accordingly, on merit, he secured his appointment. My lord, they considered my appointment, and lordship would find they had appointed.
Now it has been cancelled.
No, my lord, they have cancelled it on the ground that now I am found to be overweight and my left arm movement restriction is more than my right arm. Lordship
The
will
first consideration is not connected. This is a new.
I'm just giving a history of what has happened, my lord. Now, when
Now, what is wrong with this fine?
my lord, the overweight part, they measured me in 2018. I stayed at home till 20.
What is your weight?
My lord, now it is 69. It was 69 when
Cannot
they
be,
measured
cannot
me.
be disclosed.
No, it was 69 when I near about 90 million. Otherwise, the petitioner is 69 when they measured.
Or the weighing machine doesn't even have that much.
Sometimes it would say one at a time. To step on the machine. No, like the grounds of
Now, are you challenging the finding that you are not overweight?
my lord, they say I was 69 at that point of
What is the prescribed weight?
prescribed weight for them is 51.5 to 62.5. Presently, I'm
62.5 is the maximum.
maximum is
You are
what
69.
I was 69 on the day when they measured me, is what they have written
Now
on
what
the
have you
review
done?
medical report. Madam, now I'm 60.
60.
I'm 60. And the other ground that they have taken, my lord, the restriction of movement, madam, that is Silchar Medical College is certified that there is
See,
no
these
such
are
medical
matter. These are police force. You need to be
My lord,
physically fit.
well, also could find that if the medical, if the restriction of the arm is something related to a medical condition where it will not improve, perhaps I'm not entitled to my lord. But if it is
But
something
can
which
his
comes down with a
services be
only
utilized
review
for?
medical board would my lord.
If even if this is the condition which
Right.
you have projected, can his services be utilized for any other service?
Because they applied for CAP.
That is understood. But
Right.
how long have you served?
My lord, I was called to join. I went there. They have a review medical board on my joining. That board they rejected me. My lord. I was not allowed to
After
join.
review
I had the appointment letter. I was not allowed
And
to
this
join.
raises but overweight. That's the objective standard.
Object, my lord, if they now allow me a review medical board for the rules, if I'm
What
found
about
within
the
the
arm? What about the arm?
but arm, that is what I'm saying, my lord. When the doctors
Third
of
free arm
the orthopedic
then it counts for the petitioner who is aggrieved by an order dated 25/7/2023, whereby the candidature of the petitioner has been cancelled and he has been released from service. The petitioner had participated in a recruitment process initiated by an advertisement dated 21/7/2018 for recruitment of constable within bracket GD bracket force in Central Armed Police Forces within bracket CAPF smaller bracket force, comma NIA and ampersand SSF and rifleman within bracket GD in Assam Rifle in the year 2018. The petitioner had earlier filed WP 3809 of 2021 regarding an issue which had cropped up on his candidature. The state petition, however, was allowed, pursuant to which the petitioner was given the appointment. However, on joining comma, the petitioner was declared unfit due to overweight and movement restriction on shoulder joint, left more than right. Sarah? The Mazumdar, the learned counsel for the petitioner, has submitted that both that as on date, comma, both the aforesaid factors are non-existent, which requires a review medical board, which requires the petitioner to be examined by a review medical board. That notice is issued.
All the response.
Pre-SS. Notice is issued returnable by 4 weeks. Pre-SS Troy. The learned please accept notice on behalf of all the respondents. That extra copy of the report by tomorrow. The Chronicle.
Melosins. Malot, according to Malot, service book, Malot, his date of birth was calculated, Malot. Malot, kindly state, Malot, page 25, Malot, level look, Malot. Date of birth initially recorded, Malot, on 17 to 57. And Malot, later on, Malot, in 1990, on 2019, Malot, it was corrected as 27/4/54, Malot. 25, Malot.
A Chronicle done it counsel for the petition who is aggrieved by a communication dated 1/6/2000 by which, comma, deduction has been sought to be made from his pensionary benefit on the ground that he had overdrawn salary. The case projected is that the petitioner, who was a dispatch rider in the Assam Police Radio Organization, within the APRO bracket group, was had retired from service on 28 to 2017 while working in the promoted post of assistant sub-inspector,
Sub-inspector,
promoted post of sub-inspector
Sub-inspector.
operator. After such retirement, the pension papers were submitted. However, it appears that the petition that the respondent had made some error in recording the date of birth as 17 to 1957 instead of 27 4 1954, and accordingly his date of superannuation has been recalculated as 34 2014 instead of 28 to 2007. Consequently, the recovery has been submitted. Issue notice returnable by 6 weeks. 3 CC50 as a additional senior grant Assam except notice on behalf of responder 1
1, 4, 5, 6,
1 4 5
6, 7,
7
9, 10,
8
9, 10,
9
10.
and 10. Finance
Finance,
arbitrary finance for 3 and 11. And madam, A Lala for B Chakraborty. For B Chakraborty. Lala it comes in appearing on instruction of B Chakraborty and it except notice on behalf of responder 2. To supply extra copies of the petition be served upon the learned counsel respondents by tomorrow. Has any recovery been done?
Recovery has been not done, but my provisional person has been stopped, from from February 23.
I will obtain instruction, my lord.
From February, my lord.
The Chronicle of the Learned Council prays for an interim order. Since the issue pertains to recovery from pension, till the returnable date, the directed that no such recovery be made. And it is also, this court has also been, the Chronicle has also submitted that the petitioner has not been paid the provisional pension from
February 2023.
From February 2023 onwards. The authorities are directed to release provisional pension in the meantime. We'll give a date since it's a returnable date. Returnable product number returnable on 6th. Did I have it on? Ninth of October. Okay.
Well. Diploma.
May I please, your lordship? May I please, your lordship?
Yes.
The petitioner is a retired defense personnel who worked as a tradesman under the 57 Mountain Divisional Ordnance Unit, who retired on attaining the age of superannuation on 31st December 2017. Your lordship is pleased to get the salary fixation. He has not get fixed salary in compared to his juniors.
He has not got the benefit of revised pay.
Yes, it's not revised.
Yes, what is your name, madam? Your name?
SJ Hayat.
Here, earlier one round of litigation was there, earlier.
By the same
And-
petitioner.
Yes, and on 7/9/19, the authority wrote to the this petitioner that they are doing some time is required. I have to take instruction whether this 19 why not notice.
Have you disclosed that the other earlier your petition was filed?
Yes,
Yes,
Your
yes,
Lordship.
Where
It is annexed.
okay. Third
Page
MS has said higher counsel for the petition who is aggrieved by non-fixation of his pay and pension at the revised scale. It is the projected case that similarly situated persons have been given such benefit, whereas the petitioner has been left out. The learned counsel has also submitted that that the petitioner had earlier approached the court by filing WPC. Is it H648? H648, 2008, which was disposed of by the order dated 8/4/2009. The Parashar, the thesis, however, submit that as per instructions, some steps are being taken to redress the grievances of the petitioner. Be the resume, that notice be issued, returnable by 4 weeks. The Parashar learned thesis accept notice
All wonderful.
on behalf of all the respondents. That extra copy is served upon him by tomorrow.
Obliged.
Yes,
Maybe before Lordship. My Lord, this petition, my Lord, we are challenging the selection and appointment, my Lord, relating to Kambora, my Lord.
beginning to
Kambora.
Gambura.
Yes, my Lord.
Okay.
Kambora, my Lord. There was an advertisement, my Lord, in the year 2021, my Lord.
What are your grounds of challenge?
My Lord, two grounds, my Lord, basically, my Lord. Number one, my Lord, selection process which was conducted, my Lord, it was the merit list has not been published. Final merit list, my Lord. Secondly, my Lord, private respondent number 7, my Lord, who is appointed is lacking qualification, my Lord, even to apply, my Lord.
What is the
As
qualification?
per the criteria, my Lord, the person must possess, my Lord, land documents, land, my Lord, in the locality where he referred to apply, my Lord. That private respondent is not having to fulfill the criteria. And
Where have you stated?
my Lord, I have stated in my paragraph, my Lord, paragraph 16 and 19, my Lord.
16 and 19.
Yes, my Lord.
Is also a member of a political party.
Yes, my Lord.
Yes.
Also, appointment order was made on 29/12/22, Lord.
15.
Lordship.
And you have said that you have filed an appeal, statutory appeal. What is the
Yes.
What is the limitation of filing an appeal?
60 days, my Lord.
When did you file the appeal?
I file on, my Lord, within time, my Lord. 24, yes, 24 February, my Lord.
Then obtain instruction, Lord.
Who will issue notice?
No, issue notice, Lord.
Your Marie
Yes, my Lord.
and K. Marie had to enter counsel for the petitioner who is aggrieved by the selection and appointment of respondent number 7 as Gaon Pradhan, within bracket Gaonpura, under the administrative control of the Deputy Commissioner Golaghat. Full stop. The petitioner submits to the learned counsel for the petitioner submits that the state respondent number 7 did not fulfill the eligibility criteria as he did not have any landed property, and he was also disqualified as he was a member of a political party. That notice we should return it. One more. The Learned Council has also submitted that though an appeal was preferred under the rule, the same has not been considered. That notice we issued returnable by 6 weeks. Chakraborty for all.
3 to 6 months.
One.
3 to 6.
Revenue.
1 and 2 and
3 as Dr. Learning Council Revenue Department. Accept notice on behalf of response numbers 1 and 2. Semicolon. 3. H. Chakraborty and State Council. Accept notice on response number 3 CO2 6. Parent. That extra copy of the repetition served upon the Learned Council for respondents by tomorrow. That step be taken for service of notice upon the respondent 7 by registered post.
My lord, in the meantime, my lord, if the record may be called for, my lord.
We'll have to get you get the instruction. Basically on these two allegations.
Also, our name is not reflected in this.
Registry to reflect the name of ST Revenue City Cost.
I'm obliged, my lord.
Take steps by tomorrow.
My lord.
This case will not shift repeat.
Some talk.
Matter become
Some
infructuous.
talk. Both were smiling, so we thought that
This matter become infructuous, my lord. By
I don't know your.
quite order dated 25/8, the Commissioner Transport.
But you
has
were also
dropped the
smiling.
GP.
Lord, sir.
you were also smiling. You were also smiling. Have a look at this.
I have
I
given the
am.
exonerated from all the charges and his DP is
That's-
closed, my lord.
If you close, your lord.
Regarding the financial benefit.
Even on filing. Just by filing, you have accepted everything.
No, my lord. The process has started long back, but
Now
on
I am-
25/8, it has, the order has been passed.
Lord,
Third, we as water could turn it counsel for the petitioner
it is ordered.
who by means of this petition has put to challenge a disciplinary proceeding initiated
By
against him in the year 2019.
Lordship. Page 15.
The petitioner is working as what?
As your lordship, assistant enforcement inspector.
As an assistant enforcement inspector under Transport Department.
Lordship.
My lord.
Government of Assam. Kapara. MS MD Bora, the Learning Council of the department, however, by referring to an office order dated 25/8/2023, has submitted that the proceeding has been closed and the petitioner has been exonerated of all the charges without prejudice to the police case. Without prejudice to the CID case. Three, Water could the Learned Council for the petition agrees to the proposal court that for all practical purposes, there is no life cause of death to be adjudicated. In view of the above, the writ petition is closed. The copy of the order dated 25/8/2020 is made part.
My lord.
If
Deeply
you-
obliged, lord.
It please your lordship. Lordship, this matter pertains to the termination of service of the petitioner lordship.
Yes.
And he was an Anganwadi worker of Lala Development, Lala ICDS project lordship. Case 29 is an impugn order lordship. It was sued on 26/7/2023. And the allegation is malpractices of the government fund and negligence of an duty.
There was a DP.
Lordship, their section 9 has not been followed, Lordship. Assam Service and Discipline Service.
There's no inquiry.
Lordship, the inquiry has
Inquiry
been
was made,
conducted behind my back, Lordship,
There was
but
inquiry.
there is no presenting officers. And I am also unaware when the inquiry was conducted. Even inquiry report was also not submitted to me, Lordship.
It is a voluntary service plan on the table. That is 64 doesn't come. Because the inquiry is made, propose was given, and my additional notice by issue, my lord, I will file the petition. What is the inquiry?
When was the petitioner appointed?
Lordship, she was appointed on 2010, Lordship. That
Okay.
appointment at the
RTH Base Burwa, Learned Counsel for the petition, who is active by an order dated 23/7/2023, whereby the services of the petitioner as Anganwadi worker in the 283 number Anganwadi Center in Narsinghpur Lala ICDS project, Hailakandi, has been terminated. The Learned Counsel submits that the petitioner was appointed in the year 2010, and before passing the impugned order, the mandate of Rule 9 of the Assam Disciplinary Appeal Rule 1960 has been violated. On the other hand, Sri T.C. Chutia, the learned Additional Senior Advocate Assam, has submitted that the nature of service is voluntary, and in fact, an inquiry was held for further submit that the charges are grave, which includes allegation of misappropriation of government funds. That notice is returnable by 4 weeks. The Chutia, the State Council accepts notice on behalf of all the respondents. That extra copies of the developed on him by tomorrow.
Lordship, that any appointment shall be subject to outcome of this petition. If I succeed, Lordship,
You succeed, you'll get back the service.
much obliged.
May I please, your lordship, my lord, the petitioner was RPF constable who was appointed in 1982. Thereafter, my lord, in 97 he was dismissed from service, my lord.
1987.
97, my lord.
97.
97.
Okay.
82 he was appointed, my lord.
Okay.
Thereafter, my lord, he filed my lord, a appeal, my lord, which was also dismissed, and revision petition also dismissed. My lord, thereafter, petitioner submitted several applications for his, my lord, for considering him for the service benefits under sections 65 of the, my lord.
Are you entitled to any benefit?
No, my lord.
Then?
My lord, as per 65, my lord, section 65 of my lord, Railway Service Pension Rules 1993, my lord.
Yes.
Some compassionate allowance may be given, my lord. Direction, my lord. I have also submitted, kindly see my lord, page 74.
No, after your
Petition was
dismissal,
submitted
are you entitled in law for any benefit?
compassionate allowance is, my lord. I am entitled.
My lord,
Considering the
removal, he was
Not
charged
removal,
under-
dismissal.
he was charged under female case 326/307. Conviction was 5 years. Then he preferred appeal before the High Court.
No, we are not on the criminal case.
No, my lord.
We are on the DP.
Yes, my
DP
lord.
is a
That is
dismissal order.
Dismissal
Dismissal
order.
order does not have any other benefits. You're out.
no, my lord.
And since 1997, my lord.
My lord, my lord, after releasing from the my lord custody, he is regularly my lord, submitting
When were you released?
2008, my lord.
2008.
Yes,
And
And
now
we are in 2023.
23, my lord, 15 years.
my lord, thereafter he submitted several applications before the authority, my lord. My lord, judgment is also there been in this line, my lord. but not from Supreme Court, my lord. Railway Central Administrative Tribunal, Allahabad, my lord. Some one judgment is there, my lord.
Which paragraph?
7, my lord. Kindly see, my lord.
Provision supporting the scan. You are a railway servant.
Yes, my lord. RPF constable. So, my lord, in this case, my lord, even after my lord,
We are not satisfied. Okay, we'll issue notice.
yes,
We'll issue notice. We'll leave the maintainability issue open. Third, item number
14.
Third, the art as shown for the petition who, by means of petition, has paid for compassionate, what do you call? Allowance.
Yes.
Under Rule 65
Yes.
of the Railway Services Pension Rule 1990. The petitioner who was working as what?
My lord, RPF constable.
As an RPF constable was awarded an order of penalty dated 10/3/1997 by which he was dismissed from service. The appeal preferred against the state order as well as the revision were dismissed. It is the case of the petitioner that under Rule 65 of the aforesaid rule, even a dismissed employee is entitled for compassionate allowance, and in this regard, various applications have been filed for the authority, which are yet considered. The Parashar thesis has, however, submitted that the instant petition is not even maintainable because of the inordinate delay, and also because of the fact that the order of penalty was of the year 1997, which was upheld both in the stage of appeal as well as revision. He further submits that there is no explanation regarding the delay of about 24 years. No, not 20, more. 26 years. 26 years. And therefore, on the ground of delay itself, the petition is liable to dismiss. He has also submitted that the provisions under Rule 65 cannot be invoked as a matter of right, and everything depends on the fact circumstances. And in the instant case, the charges against the petitioner were of serious nature, wherein he was also convicted in the criminal trial. The Chauhan has relied upon don't rely tribunal cases in a high court.
Yes, that's fine. Please. But in this case, my lord,
issue notice returnable by 6 weeks. We Parashar Tilana this is accept notice on behalf of all the respondents that extra copy of the by tomorrow. The issue of eligibility on the ground of delay and latency have kept up.
Obliged.
Take this section, right?
Maybe. But in this case, the petitioner is aggrieved by the issuance of promotion offers for the post of principal diet, my lord, by violating the compromising with the qualification, my lord.
Of whom? The respondent?
Yes.
Private respondent is not qualified.
No, not with regard to private respondent. It's a general process for promotion to the post of diet, principal diet has been initiated, my lord. And as per the NCT norms, my lord, the PhD is one of the essential qualifications for the post, my lord. And in this regard, my lord, this one, I take a lordship to the minus dated.
Who are you?
I'm the one of the senior most lecturer having the PhD qualification, my lord.
You are entitled for
Promotion to the post
for
of
consideration.
Yes, sir.
And you have alleged that persons without PhD have been considered.
Yes, I'm having the PhD degree.
Lordship, similar matters was fixed on 12/9, Lordship. So later matter may be taken together.
There is interim order in that record, my lord. I'm placing your lordship, page number 70, my lord.
70.
Yes.
Yes. Yes. Okay. Third, if you people guys Senate counsel for the petition who is aggrieved by the promotional exercise undertaken by the respondent authority to fill up the post of principal DI post of the petitioner who claims to have a PhD degree as per NCT norm has alleged that the aforesaid recruitment process, aforesaid promotional exercise from persons who do not fulfill the minimum qualification as prescribed by the NCT pertaining to PhD degree are also being considered. That note that would be returnable by 4 weeks. Madam, therefore,
Respondent number 1, Lordship.
your name?
S4.
MS4. You are standing counsel.
Lordship.
Standing counsel, Elementary Education Department. Accept notice on behalf of respondent number 1. Mr. Chaudhary Estate? Yes. Whereas B. Chaudhary, understanding counsel Estate, accept notice on behalf of respondent number 1. That extra copies to be served upon the learned counsel for the respondent. 3. Forecast the place for an interim order. He has also referred to a similar order of this court passed on 28/7/2020 in WP 4255/2020. Well, following the same and on consideration of facts projected from this, it is directed that the returnable date, persons without having a PhD degree are not to be appointed to the post of principal diet.
Obliged.
Madam, we pass over timing.
What is the matter?
Promotion matter, Lord.
Do you have an interim order?
No,
Interim
Lord. No.
No. If you notice, what is your grievance?
Lordship, I was supposed to get promoted, Lordship.
Who are you?
I'm the petitioner, Lordship.
Understood, but who are you? You are a probationary officer in the
Yes,
bank.
my Lordship. I was appointed as probationary officer in 2010, Lordship.
Now you are in what? Officer grade E.
Lordship.
You belong to the reserve category.
Reservist category, SC, Lordship. Middle class category.
Your name? What is your name? Counsel, your name?
PJ Das, Lordship, on behalf of the order.
Your PJ does.
PJ Das.
Third PJ does. You're there or not?
My name is not in the cause list, Lordship.
PJ does. Learned counsel appearing on instruction of each other.
This order.
Learned counsel for the petition. The petitioner is aggrieved. The petitioner who is presently an officer of grade E category in the Assam Cooperative Apex Bank Limited is aggrieved by the action of the respondent bank in not considering his case for promotion to the next higher grade. It is submitted that the petitioner is placed in serial number 5 in the seniority list as an in the ST category, and in spite of being eligible, persons junior to the petitioner have been considered, whereas the petitioner has been left out. Correct? Let notice the issue returnable by 6 weeks. Your name?
J. Burman, Lordship, on behalf of J.K. Goswami, Standing Counsel, Apex Bank.
Sri J. Burman, Standing Counsel appearing on instruction of Sri J.K. Goswami, Standing Counsel, Apex Bank Limited, accept notice on behalf of number 1, 2, and 3.
All respondents.
Not all respondents. 1, 2, and 3. Others are by name, cannot be 1, 2, and 3. That extra copy of the written served upon him by tomorrow. Issue notice?
Yes.
We have recorded his name.
Yes.
That step to be taken for service of notice upon the respond numbers 4 CO2 21 by registered post with 80. Steps within 2 days.
May I please, your Lord. My Lord, a departmental proceeding was drawn up against the petitioner, and the charges remain unproved, my Lord. In fact, in respect of charge number 1, he was acquitted, and the disciplinary authority, without complying Rule 9(9) of the Assam Secretary Disciplinary Appeal Rules and Rule 9(a), has imposed a major penalty of removal, which shall be ordinarily a disqualification. Means he has been dismissed from service. So there is a procedure left, my Lord.
Now you say that the charge was not proved.
Yes, Lordship will kindly come to the inquiry report. Thereafter, my Lord, I was given the inquiry report, and I said, my Lord, as the charge is not proved, I may be reinstated in service and examined.
Was the second another notice given by the disciplinary authority?
No.
Then how did he act upon a charge which was not?
That is why I say, my Lord.
Mr. Professor.
Lordship, may kindly come to page 71 of the writ petition. That is the, my Lord, last page of the inquiry report. My Lord, in between. Page 71.
7-1.
7-1. It's the part of the inquiry report.
Yes, yes.
And
there was one charge, Mr. Patwari.
2 charges.
2 charges.
Yes.
What about the other?
Other charge, my Lord, Lordship, that's why I was referring to the inquiry report. Lordship, kindly come to page 84, my Lord.
No, but the last part of page 71.
Yes.
Last paragraph says that you were held responsible.
Yes.
No, that is not the report, my Lord. Lordship, kindly come to the page 84.
Page 84.
84. It is the continuation, my Lord. An objective, non-partisan, impartial, and disinterested observation on the charge number 1 level against Sri Amanda Sharma leads to the conclusion that he may be reasonably acquitted from the charge. With regard to charge number 2, it is felt that not much deliberation is required. Prosecution sanction has already been granted by the final judge. Law will take its own course. The matter is sub judice before and beyond purview of my jurisdiction. Because the criminal case is going on, these 2 are the findings of the inquiry officer. And thereafter, my Lord, I was submitted the inquiry report, and I submitted, my Lord, as I have been exonerated and there is no finding to charge number 2. I may be exonerated. Now, without disagreeing with the findings of the inquiry report and recording his own finding as is required under the law, my lord, the dismissal order has been passed. So there is a clear violation of Rule 9(9) and Rule 9 capital A of the.
Yes, Mr. Professor. The 71 is the intermediate part. Those are earlier.
Lordship will kindly appreciate, my lord, if my lord is taking up page 84, which my learned colleague has drawn attention to. Yeah, my lord, there is no, it is not in uncertain terms that he has been, my lord, cleared of all the charges. It only says, my lord, that since there is a criminal proceeding pending, my lord, the prosecution sanction may be obtained.
No, it has already been obtained. That he is saying that he has not touching that part.
No, but these findings are.
No, the prosecution sanction order has already been granted by the finance department. That is for the purpose of the criminal case. Criminal case you are not
That is a
touching.
defined case. But here, my lord, the tenor of.
How can you, without even going through the aspect of the matter, that the order, that the charges, allegation has been found to be proved? What is the objective of holding an inquiry? So that you, in the department itself, you come to a finding whether the allegations are correct or not. So for the first allegation is concerned, you said that he is acquitted.
My lord.
Maybe expression is wrong. Exonerated, acquitted doesn't mean it.
So therefore, my lord, I am going by the tenor of the language used in the inquiry. It may be, my lord, this way.
No, Mr. Proprietary, your argument has to be logical. Just don't make any argument. We are not saying that you are powerless. You should have put him to a notice that I don't agree with this finding.
My lord, notice is
What do
there
you
at
say?
page 63.
That has not been done.
Kindly come to page 63, my lord, the notice. Page 63, Annexure 12. This is the notice. 63. 63.
Yes.
Annexure 12. This is the notice, my lord.
By whom?
By the department, my lord.
This is by the disciplinary authority, my lord.
Yeah,
He has been.
with reference to the subject cited above, I am directed.
Mr. Proprietary,
My lord.
this is the second so-called notice, and he can file a representation against this.
Which he has filed.
No. If the findings are against him,
Yes.
if the findings are against him, it is only to give him an opportunity to convince the disciplinary authority to take a view which is against the petitioner.
Yes.
Now the findings are in favor. He is not even required to reply to this so-called notice.
Exactly.
And in that case, if the disciplinary authority wishes that no, I'm not convinced with the finding of exoneration, I'll again look into the evidence, because the inquiry report along with his reply is required to be examined, that whether the findings arrived by the inquiry officer was based on the material before him. What are the materials, the evidence, the material exhibits, and he comes to a different finding. So he had to put to notice.
That notice has been put.
Where? Where is it stated that there is a disagreement?
So disagreement, my lord.
This notice is a simple so-called. This is not even obliged to answer. Because the inquiry report.
Yes, for a moment, my lord may kindly come to page 90. That is the, my lord, order, my lord, penalty that has been inflicted, put to challenge here.
19.
Yes, page 90.
90.
Page 90.
Yes. Yes.
My lord, I am reading from the third paragraph, my lord. Whereas to conduct inquiry on the charges made against the Amoyendo Sama so-and-so, the Gunaganda Pegu so-and-so was appointed as the inquiry officer and so-and-so was appointed presenting of the inquiry had submitted his report by so-and-so. Whereas the report submitted by the inquiry officer in respect of the discipline was forwarded to the search officer on so-and-so. Whereas the Amoyendo Sama submitted his written submission regarding the finding of the inquiry. Then whereas the above
This discussion is rubbish. We are using this term. It is fit to be put in the dustbin. Disciplinary authority makes this discussion. He doesn't know what to do under the law. Where is his finding that he is not agreeing with the inquiry officer's report?
Rule 9(9), my lord.
From where does he come to the finding that the charges are proved? Where is the independent application of mine? And before them a notice to be given to him.
Page 90 down below, because I cannot travel beyond what is there.
What is the law, Mr. Proprietary? Proprietary, the law is that if you are not agreeing with the findings which are favorable to the delinquent, You were supposed to give him a notice
Yes,
that under these grounds I am not agreeing with the findings. What do you have to say?
right.
That is what the law is.
It is not that, it is not worded in that manner, my lord.
No, not worded. There are no materials.
My lord,
We would have understood that the wordings are not proper,
My
but there are materials that yes,
my lord.
he had thought his views
Yes,
that I intend to defer. He had not done that. How can he jump to this conclusion? The entire inquiry seems to be there first. Whatever is the inquiry report, I am not coming to a different finding. I'm not. You can come. You are the disciplinary authority.
my
You
lord
have
is
all the
correct.
right.
Yes,
But give him.
there has to be,
you-
my lord, application of mine.
Yes,
has
where are
to
the
be
case clause?
explicit.
My lord,
Case clause.
yes, my lord.
Kunj Bihari Mishra, have you got?
My lord, this honorable division bench of this honorable
Where is Supreme Court? Kunj Bihari Mishra, PNB, Yoginath Bagde,
and Kishan
Maharashtra
Singh.
case.
My lord, I have brought a division bench judgment, my lord.
Bring the case.
It's a
Findings favorable to the delinquent. If the disciplinary authority begs to defer, what is the procedure? Bring the case clause. Which paragraph?
my lord, I'll be relying in paragraph, my lord, 8 and 9, my lord. Paragraph 8 and 9, my lord.
It's not on the issue. It's not on the issue at all. Mr. Patwari, please have some, give some handle to the court. We can't do research for you. Where is that law here? That in case of an agreement, disagreement with findings favorable. Where?
My lord, it's in the rules only.
Now where is the interpretation?
My lord, in para 9, my lord.
That's not the interpretation.
Well, I'll bring the Supreme Court judgment. It is there, my lord. Possibly-
We'll have it tomorrow.
Yes. my
But when was this thing,
lord. This
penalty
was-
order passed?
Penalty order was passed on 19th
19th July.
19th of July 23.
We'll do one thing. We'll issue notice and have for admission disposal.
Yes, my lord.
Today we are not going to dispose it of. And since it was passed on July, we may not be able to pass on an interim order. But this is especially illegal. Third, the J. Patwari Learned Counsel for the petition, who by means of this petition has put to challenge an order dated 19/7/2023 passed by the Finance Department, whereby passed by the Secretary to the Government of Assam, Finance within bracket B Department, as the disciplinary authority, whereby the petitioner has been dismissed from service. It is the categorical case of the petitioner that in the disciplinary proceeding, the inquiry report had exonerated the petitioner of the first charge, and so far as the second charge is concerned, no observations have been made as there is a criminal case pending.
It's subjudice before the competent tribunal.
Pending. The disciplinary authority, however, without giving the petitioner a proper opportunity to show cause on the aspect regarding his disagreement with the findings arrived at by the inquiry officer, which were in favor of the petitioner, has passed the impugned order. That notice is issued returnable on Mr. Proprietary date.
My lord, can it be on, my lord, 28th of September, my lord, or 21st of September, my lord?
You will have it for disposal to give a date of your conviction.
Then, Lordship, can it be
21st.
Lordship, may kindly keep it on 26th of September, my lord, that will be Tuesday, my lord.
Okay.
In the
26th of-
meantime, my lord, in the
26th of-
meantime, Lordship, may kindly give me liberty to file my affidavit.
26th of September
Yes, yes, my lord,
2023.
my lord.
The Corpusary, the R. Corpusary standing on the finance for Texas notice on behalf of
1, 2, and 3, my lord.
1, 2, and 3.
Right.
5, Barbiangro. As campaign, standing counsel. He is accept notice on behalf of the court, whereas T. Chutia, an additional senior guard get the sum access for respond number 5. That extra copy can serve upon the return form by to form.
Indicated in para 22, my lord.
What? Of
Read petition.
what have you indicated?
That, my lord,
Yes,
Supreme Court
mention
judgment.
that citation.
Citation.
No, my lord, the Supreme Court judgment which says that when in case of disagreement, so-called notice is to be.
There are judgments after this.
Yes, this is the first case, my lord. Ramkrishna.
No, there are the two cases. One is Punj Bihari Mishra versus Punjab National Bank,
Yes.
1998. One is Yoginath Bagde versus Maharashtra Judiciary or something. And that is also 1998.
And
And
this
one
is-
more.
Yes, this is 95, my lord. From Ramkrishna is right.
Do you have the copy?
Right now, I don't have my.
Yes.
I'm so
Deeply
obliged.
obliged.
Mr. Corpusary, come prepared. We want to
Yes, yes,
have
my
a
lord.
proper
My lord, my lord,
assistance from you.
my lord.
And the proper interpretation has to go from.
Yes, yes, my lord. I'm obliged, my lord.
Yes.
May it please your lordship. Lordship, on 26th of January 2023, lordship, an advertisement and issued for filling up
26
250
January
January.
on a holiday.
Yes, lordship.
How is it possible? Everything is closed on 26 January.
Yes, in the date of advertisement is written, lordship, 26th of
Cannot
January.
be.
It is written the 26th of January.
How can it be published? 26 January, even the papers are
Yes,
not
true,
there.
lordship. Maybe different. Yes, lordship. But pursuant to these
What
advertisements,
is
I
happened?
respond, lordship, and participated in the selection process.
For
For the post of jail warden
jail order.
in prison department against permanent vacant post. So on recommendation of the state level lordship recruitment board lordship, I was lordship appointed, selected and appointed. My appointment order lordship will find at page 18.
You're
and except
suspended.
1. Yes, lordship. Serial number 13 is my
You're
appointment.
suspended now.
Suspended lordship, pending departmental proceeding lordship. Thereafter lordship, so-called notice issued on 24th of July.
Termination.
Charges are given under Rule 9 of the Disciplinary Rules 1964. But abruptly after 2 days, lordship,
Termination.
the-
Why haven't you gone for a departmental appeal under 64 rule?
but they have just said under Rule 20 of the Assam Jail Service Rules 1986, my service is discharged also. Although these proceedings should be drawn under the 1964 rule, but this has been wrongly, lordship, they drawn my this.
There is no provision for appeal.
No, lord, in the jail.
Wow. How? There is a provision for appeal.
The Assam Jail Service Rules 1986, lordship. I have
Mr.
come to
Chutia.
know the law. But apparently this order is.
He's a provisional, only 1 month sick. Lordship, kindly see the charges.
So he was a probationer.
Provisional,
Yeah, but
only
this-
1 month sick day.
Lordship,
He
kindly
ordered
see
in there.
this.
Lordship, kindly see page 24.
Let us see your this thing.
Yes, page 24, Lordship, kindly.
Your order of.
Lordship, kindly come to page 24 and except 4, Lord. You are hereby required to show cause. This was issued on 24th of July. Assam Service Discipline 1964, Radio Article 11, Constitution of India. Why any personalities? Prescribed in Rule 7, charge 1. On 16/7/2020.
Mr. Dekra, the charges are very minimal. No
Lordship,
charge at
although I
all.
have not admitted, Lordship,
You have
Mr.
quarter
Mr.
ended.
Chutia,
but this,
see the charges.
Yes, yes, quarter ended. The main get
but
What related with what?
article cigarette, bhang,
Cigarette,
gutka,
vodka, bhang,
pidi,
bidi,
levo,
cetirizine, tablet.
tablet. Very, very such, and he was only 1 month, 6 days he served.
that's true.
What
But
penalty have you given?
Malad, we will
Only
not.
termination.
Yes,
Yes,
page
Lordship.
27.
No other penalty. Severe
No.
name.
no, although I am,
Simplicity, Malad,
it is not simplicity, Lordship. The
Page 27, Lordship, kindly see.
No, he was. You should have given him more severe punishment.
So, Malad,
Jail order with narcotic drug contraband,
the termination order.
and that too in probation.
Unity,
Yes.
Lord. It is not.
What will you do during your later part?
for at all. That too in the jail, my lord. So page 27, last what you can see. Last part 1, whereas it is noted that Raju Thakur, warder, has completed only 1 month, 16 days in his service period of on 16 July 2003. In view of the above factors.
In 1 month, you have started doing this.
Yes.
There is some lordship actually, I don't like to disclose here. There's some conspiracy going on, lordship. But
Conspiracy?
my here lordship is lordship. But here lordship, my anxiety is that lordship, although I am in probation lordship, this is not lordship. It's a punitive in nature lordship. It is stigmatic also.
How it is stigmatic?
Because under rule 9 they have to follow the procedures lordship. It is not followed.
That is the impugned order 27.
27.
27.
Order in.
This is based on the report, the second paragraph, whereas the superintendent Central Jail Guwahati furnished a report. So this report has been lordship prepared behind my back lordship. And regarding the fact that while routine checking of all guarding staff on duty was being carried out on 16/7/2023 in the presence of jailer, assistant jailer, and other guarding staff, there are two. Yes, lordship. A detailed report on incident of recovery of contraband articles from the aforesaid warders from their persons and from their living quarter was furnished, guide letter, so on. But this was not furnished to me, lordship, to give my reply, lordship. Now, whereas the second part, last paragraph, lordship, whereas it is noted that Raju Thakur order has completed only 1 month.
May not be a case for interference.
A bit dangerous.
Unless you say that it is malafide. Read court will see your contact.
Because list, lordship, if we go to the so-called lordship list of witnesses
for the petitioner who has put to challenge an order dated 27/7/2023 issued by the Inspector General of Prisons, Assam, whereby the petitioner who was appointed as a warder
in the jail
as a jail warder was discharged from his service under Rule 20 of the Assam Jail Services Rule 1986, read with explanation within bracket small g within bracket small 1 to Rule 7 of the Assam within bracket Discipline and Appeal bracket close Rule 1964. The petitioner was on probation and had just completed more than a month, and the allegation is that he was found to be in possession of contraband articles which were hidden under his cap, shirt, pen, shoes, etc.
Wallet.
The Dhaka Electronic Council, however, that the aforesaid penalty cannot be treated as a discharge simpliciter,
Lord,
as allegations have been leveled against, and therefore he was entitled for a fair approach.
Lord.
That notice should be returnable by 6 weeks. Or we issue rule. That rule be issued returnable by 6 weeks. 3. Each should be allotted additional senior advocate Assam. Accept notice on behalf of all the respondents.
All the respondents.
All the extra copies of it out upon him by tomorrow.
Apply, Lord.
May please lordship. The matter is pertaining to selection and appointment of Gambura lordship. Lordship, yes, lordship on 10/12/2018, respond number 4 had issued an advertisement for appointment of Gambura in Baksa district lordship. Therefore, in presence of the said advertisement, the petitioner have participated in the said selection process, and accordingly they have duly appeared before the interview test. Lordship, therefore, in the year 2019, some of the persons have challenged the said selection process pursuant to the said advertisement before the honorable court, and this honorable court lordship by order and judgment dated 18/7/2022 passed order whoever dismissed the petitioner's claim lordship, and direction was given to the respondent for to declare the result lordship. Therefore, till today they have not declared any result lordship.
Why are you so late? The petition was dismissed when 18/7,
Yes, Lordship.
2022.
Yes, Lordship.
You've come to this court after more than a year. Why?
Lordship, in that case, we have all implemented the response number.
The writ petition was dismissed. The writ petition is put to challenge the selection process, isn't it?
Yes, Lordship.
It was dismissed on July 2022. What took you more than a year to come to this court?
Lordship, we have approached the before the response number, but they have called verbally as soon as the result will be declared soon. Lordship.
The advertisement is of the year 2018.
Yes, Lordship.
We are in 2023. 5 years have gone. You can say that from 19 to 22, there was a case pending.
Yes, Lordship.
But in 22 July, case was also rejected. It should have come immediately. Okay. What is your name? Name?
Jay Hatimuriya. Lordship.
Jay
Jay Hatimuriya.
Third page, okay, then now for the petitioner. The petitioners were aspirants for the post of Gaonpura in the district of Baksa. Though the advertisement was of the year 2018, in which the petitioners had participated, there was a writ petition being WP 5665 of 2009, challenging the state recruitment process. The writ petition, however, was on 18/7/2022, and even thereafter, no steps have been taken to fill up the state vacancy. That notice be issued, returnable by 4 weeks. The CC should hear the learned.
I am for 5 only. Five only.
Or that revenue for as Dr.
Your Lordship, I am appearing for
As Dr. revenue as state technical revenue for 1.3.
4, 6, and 7 for PPC
D Das
on behalf of
on behalf of P Nayak, understanding of the petition for 4, 6, and 7.
6 and 7.
And it should be done. Yeah, consider for response number 5. That extra copy of the written is served upon the learned counsel for the respondent within 2 days.
Lord, in this case, Lordship, the petitioner was an Anganwadi worker, Hailagandi ICDS project, Lordship, and her service was terminated on 26 July 2023. Impugn order is placed 27.
Why terminated by?
Lordship, the misappropriation of an government fund and negligence in duty, Lordship.
Same like the other one.
Yes, Lordship, item number 13.
What? Same order will.
Lordship.
आंगनबाड़ी सेंटर का नाम दे दो नंबर है नो 167 आंगनबाड़ी सेंटर हाइलाकांदी और ये टर्मिनेशन ऑर्डर है 26 जुलाई 2023
Much obliged.
We have to report. Lordship, the petitioners, Lordship, they are working as a assistant fishery officer. And assistant fishery officer.
Fishery officer.
And allied cadre, Lordship, and their next promotion is fishery development officer. And Lordship, as per the service order, Lordship, the 75% post of fishery development officer is required to be filled up for direct requirement and 25% from promotion and quota. And Lordship, as per the service order, Lordship, we have the requisite qualification for promotion as FPO. But in the meantime, also we had earlier filed a writ petition by the association seeking promotion from the gradation list. In that case, Lordship, they have filed an affidavit that although the their order is still in force, but that is an outdated one, and they are contemplating to bring a new rule. So as to cope up with the scientific teaching. Thereafter, Lordship, this honorable court has passed an order
Lordship, may kindly see at page 15, page 109.
There is a decision to upgrade your
Now, there
services
is they have proposed a scheme to upgrade the fishery inspector and
assistant fishery officers to fishery inspector, fishery farm surveyor.
And
Yes.
we have concentrated all the concerns, but they are taking time and also, and most of the persons have retired. We are on the verge of retirement.
Sri S.K. Das, Leonard Counsel
Lordship,
for the-
I am praying for disposal of the writ petition at the motion stage itself by if a time-bound manner. Lordship, can-
No, my lord, let me.
Let him have the instruction. Sri S.K. Das, Leonard Counsel for the petitioners who are presently working as assistant fishery officers, AFO, in the establishment of the director of fishery. The next higher post is the post of fishery development officer, and under the orders of 1918, under the Assam Fishery Service recruitment and promotion orders of 1989, 25% of the vacancies were to be filled up by such promotion. However, since no promotions were made for a long period of time, a writ petition was filed by the association in which this court was apprised that there that that there that appropriate steps to be taken for upgrading the existing post of the fishery assistant fishery officer or to assistant officer to the post of fishery inspector, fishery farm supervisor. Though the petitioners in principle had conceded to the state proposal, even the state proposal have not been implemented, as a result of which grave prejudice is being suffered and the petitioners are stagnant. It is also submitted that many of the assistant fishery officers have retired in the meantime. That notice be issued returnable on give a date.
At the earliest convenience. At the earliest.
Returnable on 25th of September. 25th of September. That free TC to be done. Accept notice on behalf of respondent numbers
1, 2, and 5.
2 and 5, whereas MS Mohanto, D. Mohanto, P. Sharma, Learned Counsel assisting Sri C.J. Mohanto, Learned Senior Counsel, accept notice on behalf of respondent numbers 3 and 3. Finance name, your name. R.M. Burua. R.M. Burua, MS R.M. Burua, Learned Counsel, appear in instruction of the earlier Senior Counsel Finance Department. Accept for respondent 4. That extra copy of the written is served upon the Learned Counsel for the respondent. The Learned Addition to the government is, however, directed to obtain instruction regarding the steps taken to implement the new scheme, which was disclosed at the time of consideration of the earlier petition WPC 1492 of 2018. It is further observed that tendency of the petition shall not be a bar for consideration of the case of. Yes. Yes. Dismissal from service, my lord.
Dismissed from service.
Dismissed from service.
What post?
My lord, Havildar in the Assam Police Battalion.
After the DP.
DP was there, my lord, but none of the.
Will issue route. What DP is the current account? Assisted by who?
As
M. Khan.
Yes, Islam.
As Islam.
by
Who has put to challenge an order of dismissal from service of the petitioner by an order dated 25/2/2023 by which the petitioner has been dismissed from service as an Havildar under the Assam Police
Battalion.
Assam Police Battalion.
But the appeal is also pending, my lord. That has not
The
been-
Senior Council submits that under the rules governing the field, an appeal has been preferred in the department, which is also pending. So that rule be issued returnable by 6 weeks. The CC should be allotted additional senior on behalf of all the respondents. That extra copy should be served upon him within 2 days. Defendants shall not be barred for consideration and disposal of the department.
In the meantime, my lord, they'll file the affidavit also, my lord, because man is out of service, my lord, and apparently, my lord, none of the rule has been, my lord, followed.
The compulsory appointment, my lord, in Master, it is not covered by the scheme, my lord. Her mother was died. Mother was died and father is working.
I don't know, 24.
24.
Yes. What is this?
Lordship, the petitioner is a physically challenged person and having handicap certificate by the annexure 4 and 5. Case number 25. Lordship, the mother of the petitioner died of cancer on 25 January 2014 while she was working in the Water Resource Department in the office of the Executive Engineers, Sonitpur. By death certificate annexure 2, case number 70.
Thereafter, what has happened?
Lordship,
What is your grievance now?
Lordship, thereafter the petitioner applied for a post for the section assistant under the compassionate ground of his mother's work.
Your father is in service.
Yes.
Yes, my lord.
Case 23, my lord.
When is it when the sole earning member passes away?
My lord,
Dependent.
the father
It
is
is not a source of appointment.
the father is
This
a
is
heart
a
patient.
deviation from the source. Huh?
Lordship.
Father is not in employment.
Yes, my lord.
Then?
Lordship, he is a heart patient.
Maybe.
But that's a different matter.
And
what's the scheme? When there are no other earning members, the sole earning member has passed.
Only dependent one.
Lordship, the petitioner is a physically challenged person.
That is a different matter. You can participate in a recruitment process. There are particular posts reserved. But compassionate appointment, if you are not mistaken, your conception is not correct. Third, your name?
M.A. Chali.
M.A. has done a counsel for the petitioner, who by means of petition has to challenge and ordered it and have put to challenge the minutes of meeting dated 27/9/2016 of the state level committee, which had considered the case of the petitioner for appointment on compassionate ground. So, it's the case of the petitioner that his mother
Hira Devi was an employee of the Water Resource Division at Tejpur and had passed away on 25 March 2014 by service. The petitioner also came 40% physically challenged and has obtained and has passed the higher secondary examination in the year 2011 and has also completed certain other professional courses. The rejection the learned council has submitted that the aforesaid factors were not considered and his case for appointment on compassionate ground has been rejected. Para 3 CCCT of the learned additional senior exam, however, submit that the order of rejection contains reasons which are not only which state that the committee has took into consideration the fact that the father of the petitioner is in government service. The state council according to submit that the state consideration is a relevant one and therefore no case for interference made out. The scheme for compassionate appointment is in deviation of the usual mode of recruitment, whereby a certain percentage, 5% of the vacancies are given to persons who fall within the scheme of the scheme. In that case, the objective is to give the bereaved family which has lost the sole breadwinner immediate succor so that they can survive. However, in the instant case, it is not true that the father of the petition is in government service, and therefore this court is unable to accept the claim of the petitioner that the impute rejection is bad in law. Accordingly, this court is of the view that no case for interference is made out, and the decision according to this dismissed full stop. The petitioner, however, is at liberty to apply and participate in any recruitment process by our recruitment process in which there is a quota fixed for persons with PW.
May I please?
25.
Yes.
Yes.
Your Lordship, the petitioners, they were the seasonal employees of Naga Sugar Mill, Your Lordship, which was closed in 2002. So the government has issued a notification in 2006 by which these employees were given the retirement, voluntary retirement. So most of the employees, they got the benefit, but these petitioners were left out. So they have approached the honorable court for this benefit.
When was it closed down?
It was closed in 2002, but notification in 2011, this liquidator was appointed for settlement of all the dues.
Now, have you approached the liquidator?
Yes, Your Lordship.
What is that?
On number of occasions we have approached, but he refused to pay any heed to our grievances. So we have submitted a representation to all the respondents on 6/3/2023, but we have not received any reply from their end.
How have you explained your delay?
Lordship, most of the petitioners, they are from other states, Your Lordship, UP and Bihar. And some are from Assam, but they have been doing job in other states. So they were not aware of this this development, Your Lordship. And after the COVID is over, when they come back, they know about this and they have approached, Your Lordship.
Not convincing at all. You sleep over your legal rights. How can you approach a court of equity?
Your Lordship, the mill has closed down. So they have
When
this
was it closed down?
in 2002, Your Lordship.
Now we are in 2023.
Yes, Your Lordship, but the liquidator was appointed in 2011, Your Lordship.
From 11 to 23, what have you
No,
done?
the petitioner, he approached in 2011 itself.
And what has happened?
But due to some internal differences among the employees, he has
You,
to step
you,
down, Your
you,
Lordship.
you take 12 years to reach the High Court. Is any final orders passed by the liquidator? Where is the proceeding before the liquidator? Which paragraph? Which connector? Where is your application to the liquidator?
Yes, Your Lordship.
Where are your applications for the liquidator?
Annexure, Your Lordship. 6, Your Lordship, at page 77. This is our representation, Your Lordship.
77.
Yes, Your Lord.
When? Date?
Date 6/3/2023, Your Lord.
From 11 to 23, what were you doing?
No, Your Lordship, earlier writ petitioners, they have
Let us
approached
see.
in 2006, Your Lordship.
Where?
Because earlier what happened, this voluntary retirement benefit, it was not decided as per the BRS policy of 2006. So they have approached for enhancement of this BRS in 2016, and the order was passed in 2020, Your Lordship. So after knowing this, only the petitioners, they have
You
approached.
are not on the enhancement scheme. You are only that some of you have not even got
No, Your Lordship, I'm for the retirement benefit, Your Lordship.
only for the retirement benefit.
Yes, Your Lordship.
Which
As per notification of 2006, Your Lordship.
2006 notification, can you claim in 2023? Don't you think that is barred by time?
They have their
How have you explained the delay? Where? Which paragraph?
in paragraph 11, Your Lord.
11.
Yes, Your Lord.
Please read.
The petitioner humbly begged to state that they were not made part of the earlier writ petition, and as such, the petitioners were not aware of the order passed in or WPC number 7969/2016 and subsequent development. That is paper publication asking for submission of document claiming VRS benefit. The reason being that some of the petitioners were residing in other states like Bihar and Uttar Pradesh, and some of the petitioners from Assam working in other states like Hyderabad and Chennai for livelihood, Your Lordship, and some have died. Due to this reason, the petitioners were unaware of the development which led to the deprivation of legitimate use.
If your association, if your leader does not intimate you, it's your fault. These matters are to be espoused by the union. It's not an individual dispute. And it appears that earlier there were writ petitions.
Yes, the 4 writ petitioners were there. 2 have died during the pendency of the earlier writ petition, Your Lordship. And 2
Yes,
they were.
Butler.
Otherwise, the liquidator has published the notice on 10th of May 2011 itself.
Where page?
Page number 67, annexure 4, Your Lordship. Since 2011, now it's 2023, Your Lordship.
Lordship, after the appointment of liquidator, the petitioner he approached, Your Lordship, and
where have you stated? Where have you stated where is it an approacher that he had approached?
On paragraph number 13, Your Lordship.
1-3.
Yes, Your Lordship.
Yes, let us read on.
That the petitioner back to state the petitioners approached respondent number 6 on several occasions requesting
When?
to clear the dues.
Several occasions when?
After the appointment of liquidator.
Where? Where have you stated? Several occasions when? Which date? Where is the annexure?
No, Your Lordship, verbally they have went, Your Lordship.
You verbally approach the liquidator.
And as per the they have also got two installment, 1,000 each, Your Lordship, but not as per the revised policy of 2006.
What is your name?
S. Dekha, Your Lordship.
How to pay as the current conflict for the petitioners who the petitioners. It is the case of the petitioners that they were seasonal employees of the Arthur Nagaon sugar mill, which was established at Kanpur in the district of Nagaon in the year 1986. And they were appointed sometime between 1986 and 1997. The petitioners claim that they were provided with regular pay and allowance. The state mill was, however, stopped production in the year 2002, and by an order dated 1/11/2010, an official liquidator was appointed. It appears that certain other employees had approached this court by WPC 7969 of 2016. However, the petitioners claim that they were serving somewhere outside the state and were not aware. Sarah, Sri G. Butler, Senate Council for the Senate Council Corporation Department, however, submitted that the liquidator was appointed in the year 2011 itself, and there is no explanation regarding the inordinate delay in approaching the court. He further submits that there is no document that to establish that the liquidator was approached in which there was any consideration. Court of Para. Be that as it may command, that notice be issued returnable by 6/3.
I appear for respondent number 2, 5, and 6.
Mr. Dekha,
Yes, Lord.
what is kind of display? Come to page 7.
Page 7, Your Lordship. Most of the petitioners, they have died, Your Lordship.
So how do you make them parties?
They are being represented, Your Lordship.
Representation, the party who is surviving has to be the petitioner. This is not the way you draft a petition. You see, you have said petition number 5, Mohan Kolita, we didn't make it expired.
Yes, Your Lord.
Mohan Kolita cannot come up before this court.
No, Your Lordship. He is being represented, Your Lordship, by his legal hair.
This is a writ petition. First
Yes,
time you are in the court, original proceedings.
Yes, Your Lord. But they have done no remedy, Your Lordship. How they can claim for their
The representation is cannot, the wife cannot be a petitioner.
yes, Lord.
How can a deceased person be a party? This is not a continuation of a proceeding that somebody has passed away, so you substitute. This is an original proceeding. You say so and so who is representing the deceased employee. There are many persons who are expired. 6, 5, 6. Petition number 5, petition number 6, petition number 13, 19, 20. Reasonable by Sri Butler, the Understanding Council has also pointed out that in the area of parties,
The expired employees have also been made petitioners, which petition three bottle and training council, corporation department, except first is chief secretary. Three TC should be done at addition to number one.
One and
One
three.
three.
One and three.
One three. The G bottle understanding of corporation department. Except notice of the responded 2,
5 and 6.
2, 5 and 6. Liquidator will take.
I will take.
Liquidator.
Liquidator I will be appearing. 2, 5 and 6.
2, 5 and 6. Finance department. Higher proprietary. Understanding consequence conference. The Learned Council for the petition of the Decca. Praise for liberty to file appropriate IA for adding the proper parties in this petition. Liberties from.
Hold on.
May it please the Lord.
Yes.
Let we are agreed by the order dated 8/5/2003, by which the petitioner was compulsory retired, my lord. The provision of rule regulation 22, my lord.
After a DP?
No, my lord. It's my lord. It's a
clap that
weeding out the deadwood, my lord. That concept in terms of circular dated 9th July 21. Lord, that termination is retirement is in the teeth of the circular is per se illegal, my lord. It says, my lord, the conditions that if he's been promoted in last 5 years, my lord, generally he should not be. Lord, in 2021, he's been promoted at DGM. Lord, his ACR records are, my lord, outstanding. And Lord, there is a provision for submission of representation. We had submitted, my lord, and that
are to be run it council for the petition. The petitioner was lastly posted as
DGMM, my lord.
DG?
DGM. DGM, Deputy General Manager.
DGM?
My lord will see the at page 20.
DGM or
DGM G General.
DGM G in the FCI and is aggrieved by an order date. Is it 85?
Yes, my
2023. Passed by the managing director, whereby the petitioner has been compulsory retired with effect from 8/5/2023. Full stop. In the specific case of the petition, that the conditions for exercise of such power of compulsory retirement are apparently absent, and rather the performance of the petition was such that he could not be treated to fall within that category who could be considered for compulsory retirement. That would be.
Can I pay for notice, my lord? Because he has some, but the circular itself says, not if the interference is by the court, my lord, he can be reinstated.
Where?
Not at page 47, your lordship would see.
At least they have recognized or acknowledged.
But acknowledge, Lord, that one has to approach your lordship. Because the, Lord, then no reasons has also been assigned.
Notice be issued credible by 6 weeks. Be casing the understanding of the FCI. Accept notice on behalf of
all the respondents.
All the respondents. That extra compulsory came by tomorrow.
My lord.
Come up with instructions.
Yes, my lord.
Perhaps we can do something at that.
My lord. Can this observation be made?
Okay, let him come.
Because I am not praying.
Let him come up with instructions.
My lord. Thank you.
Lordship, my learned friend mentioned the matter, Lordship.
Yes, yes. Madam, they have some difficulty. You are not there, so we. Somebody is not aware of something has happened. What has happened? You want some time?
Affidavit has been filed.
Affidavit filed.
Where is it, gentlemen?
Lordship, he has some personal problem. He already left.
Who?
Mr.
Mr. Sinha.
Sinha.
This court has been informed that BC is having some personal difficulty. Also heard and standing on. Animal husbandry. Age and correct. As agreed to by the parties. Please on. Please after 2 weeks.
Obliged.
Lordship, can it be taken up on Friday or next Friday, Lordship? Because some instruction has been sent to my mail. I could not go through it, Lordship.
That I have difficulty, your lordship, because on the last date also the same request was been made. And hardly if your lordship may pursue this writ petition, there is no any difficulty that in the same line.
We'll have it on Friday, this Friday. 2 days will not make any difference.
Because we have taken recourse to 161 because we have not called inquiry. So that satisfaction will be
Do
necessary.
you have the
from
records or not?
Lordship. Lordship,
You have the records.
it has been sent to my mail, Lord.
Your lordship, they has directly hold up in 161 sub rule 2, but without touching 153. So that is what there is a sufficient portion of law.
A prayer for return by return. On the other hand, urgency has been expressed on behalf of the petition. Yes, tell us agreed.
Friday should be last opportunity.
As agreed to by the parties, please on. First of September. First of
This matter, I filed one additional affidavit yesterday.
That the court, lordship, that may not be required because additional affidavit has been filed to bring into record the last date of submission of the form, which they have admitted in their affidavit only. So, lordship, the issue is
that the affidavit come on record since I filed it. It cannot make it.
You have filed.
I filed yesterday. I have given him a copy to file yesterday.
Yes, lordship, he has filed that in their main affidavit. That the additional affidavit has been filed to bring into record the last date of submission.
Yes, when we will have the affidavit. When
any date on
next
Yes.
Thursday. Thursday.
Yes.
Next Thursday.
Next.
Monday, Tuesday, Wednesdays are holidays. We'll have it Friday, Thursday. The Ganguly standing on C and B has submitted that an additional affidavit has been filed yesterday, which however has not been tagged with the record. Compare this on 7th, will be 7th of September, 7/9, along with the affidavit, along with the additional affidavit.
Interim order will be continued.
Para interim order passed to continue to the next day.
Obliged.
Yes, what is this?
In this case, petitioner paying for
Yes, instruction.
Yes, we receive instruction. So, there is no record for engaging the petitioner in the Anganwadi helper, and there was no also advertisement also. So,
You are protected by an interim order.
yes, ma'am.
You put this on record.
Follow the.
Was there any recruitment process?
Yeah, that had been installed, my lord. The advertisement is stopped.
No, was there any recruitment process by which he was inducted in the service?
No, there is no recruitment process when he was engaged. He was engaged only when another person is retired, somebody has engaged.
Without any process.
Without any interview, without any input.
You put this on record. Will put the file and affidavit.
File and affidavit.
Then we can at least still have a chance. We can,
Yes.
We can dismiss this. Then.
Yes. I will bring this instruction on record. my lord.
This should be a learning of additional senior submit that as per instructions received, the induction of the petition as Anganwadi helper was not proceeded by an properly conducted recruitment. He was conducted only when a vacancy arose on the retirement of the earlier
Incumbent.
earlier incumbent. That is on record by way of a statement for which 3 weeks time.
Obliged.
This copies we can have it or
Yes, I don't know him. I will have to take.
we'll make the copies here or you can give a copy. For
Made please, Your Lord.
you file some affidavit today.
Yesterday it has been brought on. It's a reply affidavit, my lord. Now, a very important question of law arises in this case, my lord. The petitioner before lordship is an APS officer. A particular disciplinary proceeding was initiated against him. My lord.
Yes, Mr. Sutia, you are there?
Yes.
What is the what is to be done today?
We have
A short point is involved. If a lordship finds it takes longer time than lordship, but
You are protected by an
I am
intelligence.
for the
There is
No,
an
there is an interim order, my lord. But question is, my lord, my promotion, my confirmation has been held up. My lord, there was a DP instituted. The DP
you
was
are
dropped.
you are an APS officer.
APS officer. Assam
DP was dropped.
DP was dropped.
Thereafter,
Now, my lord, based on the finding in the inquiry officer, pursuant to which DP was dropped, now and again a search sheet has been issued. An unheard of thing.
that cannot be done.
Kindly see one sentence, my lord, page 37. Last para. Last but one. After careful examination of all statement of the witnesses, it is proved that Bhaskar Oza, the then DSP headquarters Dhubri, had received an envelope from Ariful Islam through his residential orderly Krishnanath. In his defense statement, Bhaskar Oza admitted to have received an envelope, but stated that it contained a CD. Further, during examination by inquiry officer, he stated that CD was relevant to case number so-and-so, of which he was investigating officer. Also, during examination, he stated that he did not report about receipt of CD to his supervisory officer. I neither sees nor mention about it.
But
In the case that
the charges had to be proved.
yes,
Thereafter,
no, upon under the circumstances, no, kindly see, this is important. Under the circumstances, above charges of gross misconduct, undisciplined conduct, and dereliction of duty on the part of Bhaskar Oza, the then headquarters Dhubri, has been proved.
Proved.
No, no, my lord, this is the impugn order. As far as, my lord, the order of the disciplinary authority is concerned, next page, page 38. Based on this is the, my lord, inquiry report.
the inquiry report has held that it was proved.
Proved. Now,
Thereafter,
my lord, this is the view. Next page.
Yes.
Whereas having examined all the statement of witnesses, it has been found most of them have denied the charges leveled against Bhaskar Oza. In view of it is deemed to fit by the disciplinary authority to drop the departmental proceeding against the officer. Now, therefore, Governor of Assam is pleased to close the departmental proceeding against Bhaskar Oza, APS then so-and-so. Accordingly, disciplinary proceeding against Bhaskar Oza, the then so-and-so, is thus disposed of. Now, after this, my lord, a show cause notice has been issued at page 13.
the disciplinary authority did not agree with the findings of the inquiry officer by which he was held to be guilty.
Yes.
And he exonerated the
From all
petitioner.
charges.
Thereafter, what is that?
Thereafter, now again a charge sheet has been issued by him, saying that inquiry report reveals something. But that has been acted upon. How can that be the premise for initiating a disciplinary proceeding? My lord, there are other, my lord, supposing the disciplinary authority may agree, may not agree, there are other ways and means of dealing with the situation, my lord. But certainly issuance of a fresh show cause notice is not the only answer, my lord.
And this new show cause, impugn show cause. This,
Yes, new show cause is at page 39.
Page 39 is based on the same allegation.
Same.
The CD.
Same scene. in the envelope.
Kindly see, my lord, this line about one.
Yeah. Was this order review? Was this order at any point of time taken for review? How can you so much?
They could have reviewed it under Rule 26.
They have not done so.
They have not done that. They have issued a so-called notice because giving an opportunity in thinking.
When? It's the initiation of a fresh inquiry. You cannot do so.
They got the CD. That was the later on that was discovered. That's why they given opportunity to the petitioner.
No, see, as a court of law, we are only examining the procedure.
Yes, decision-making process.
The decision-making process does not appear to be in the correct manner. You may have good intention, bad intention, that's a different matter.
Definitely,
but when the disciplinary authority had passed a final order, we do not even know whether you have two motor powers of reopening. But that has not been done. You initiate a fresh inquiry altogether.
Second DP.
And in the affidavit filed by the state, my lord, they have made a wrong statement. I won't say false, it's a wrong statement. If your lordship will kindly take the affidavit filed by respondent number 3, paragraph 5, at page 45, my lord.
Art 3. Art 3.
Art 3, my lord, yes. Page 45. That with regard to the statement made in paragraph 10 of the writ petition, the deponent begs to state.
Paragraph?
Paragraph 5.
Yes.
At page 40. That with regard to the statement made in paragraph 10 to the writ petition, the deponent begs to state that the disciplinary authority examined the inquiry report submitted by I.H. Bora, IPS. The inquiry officer found that the charges of accepting bribe in the form of cash by Bhaskar Oza could not be proved. At that envelope, my lord, they say, somebody says it could contain cash. I said it contained a CD. So they say, my lord, it was not proved. It was proved. Despite, my lord, proceeding was dropped. So the very basis of initiating de novo proceeding, in my humble submission, is not correct. And in any case, my lord, in view of the decision of the Supreme Court, in my lord K.R. Dev's case, of course, it was in the context of Rule 15 of the CCA rule. Similar provision is Rule 9.
72.
72, my lord. It contemplates only one inquiry. Supposing, my lord, disciplinary authority finds that particular evidence was not properly appreciated, or, my lord, there are some aberrations in the inquiry, then from that stage, that can be started. But there is no system of replacing one inquiry officer by another inquiry officer and proceeding with de novo.
No, in fact, maybe your case is been on a better footing.
Yes.
We have come across cases where the inquiry report was in favor of the delinquent, and again a new inquiry started.
Yes.
Court has said that you cannot continue. Either you can disagree, give a fresh.
Exactly.
But here it's again worse. Inquiry officer was against you. Report, but disciplinary authority
said that
he examined everything, but he said no, matters are not against you. He comes to a finding.
Yes.
Thereafter, how do you again reopen the entire?
On the ground that the charge was not proved. Charge was proved.
The affidavit they say, paragraph 6. However, the Supreme notice dated 8/12/2020 is not based on the same set of allegations against the charged officer. Seizing or not seizing a CD, compact disc, and not reporting it to the supervisory officers were not part of the allegation in the Supreme notice on that.
No, we can tell one thing, Mr. Chair. We are not too much interested with what has happened factually. We are only interested in the procedure. The disciplinary authority being the head, he comes to a conclusion that the officer delinquent is not guilty, exonerates him. Then after that, can you start a fresh proceeding
on the same charge?
On the same charge.
They say it is not same charge, because this CD is later on that they discovered. They say. So they could have gone for review. Remand it for the liberty may be given to for review this matter.
That is up to you. Why should we advise?
No, otherwise that is this system is they according to law under Rule 9 de novo position bar. So they cannot do it. So, but they stated in the affidavit.
Yeah,
they
Dean,
stated-
Dean opposed, but the disciplinary authority could have concurred with the finding, and matter would have taken a different dimension. He could have challenged or not challenged, it's up to him. But disciplinary authority chose not to accept the findings and exonerate the petition.
That is up to them.
And it is the disciplinary authority who has filed this affidavit of opposition. Reply this affidavit of opposition, 24 July.
Secretary.
Yes, what should be done? Today, 2 o'clock we have fixed for a judgment, and 3 o'clock put the rising paper of reference.
Allah will fix another day, convenient.
But we have heard this. We'll fix it on Thursday then, but only for formal.
My lord.
If
After.
you want, you can place some decision.
My lord, I'll place that. After.
Today, Thursday?
Yes.
You are there on Thursday?
I will be there.
What we can return account for the petition accepted by the RMTech. The reply affidavit filed on behalf of has been tagged along with the record.
On the
The Senate Council has submitted that considering the issue involved and law holding appeal from the matter can be taken up for disposal at the admission stage itself. The EC should be standard admission submit that affidavit of opposition has been filed on 24/7/2020. This proceedings are complete and also having got this issue involved raised it with this for admission on
7/9.
What was the interim order?
This order was stayed, my lord. No further proceeding.
Interim order after continue to the next set of. Why for orders for effort?
Actually, it should have come up for admission.
No, because affidavit.
Today it has come up for admission, my lord. Admission. My lord. My lord, can I make one small prayer, my lord? There is one item 39. My lord, it pertains to pension to the retired employees of Dibrugarh University. After the judgment around 3 o'clock, if a lordship will kindly take it up, my lord. Because today court will rise early also. The other day, yes, my lord. I'm deeply aware. We'll inform the other side.
May it please the Lord. Your Lordship, otherwise the issue involved, if your Lordship recollects, with regards to the date of suspension order as to when it is effective, whether it is effective from the date of issuance of the suspension order or whether it is effective from the date of receipt of the suspension order. To that effect, if, on last occasion when it came up before your Lordship pointed out that there is a judgment to that effect that it is effective from the date of communication, from date of issuance. And I placed on judgment when it came up before your Lordship in another court, that is a Khemiram judgment, State of Punjab versus Khemiram. And as per that particular judgment, it is effective from date of issuance of the order and not from the receipt. So my this particular case is covered by that particular issue only as to when suspension. Now the Deepak Mali judgment settles the law. Law is settled with regards to Deepak Mali judgment. That review has to be taken place before 90 days, not even 98 days. And in my case, the only predicament here is as to when this particular suspension order is effective. As far as my understanding goes, it is from date of communication, from date of issuance of the suspension order. And from that date, the 90 days period should start. And in my case, the suspension order was issued on 1st of November 2022, and the 90 days period it ended on 29th of January 2023. And they issued the extension order on 3rd of February 2023. I received a suspension order on 7th of November, and they are counting the date from 7th of November till 5th of February. They issued the suspension extension on 3rd of February. So that is the small issue involved as such.
My lord, on this matter was on 1st of August, my lord, heard by Honorable Justice K.N. Surana, my lord, and there is an order passed, my lord. At length, my lord, on that particular day, it was hard, my lord.
Thereafter,
Thereafter, my lord, I'm reading the order plus from the Honorable Court, my lord. One submission made by learned counsel for the petitioner was to the effect that the order of the first review of suspension of the petitioner was issued on the 3rd 3/2023, which was served on 12/12/2023. Accordingly, it is submitted that even if the initial order of suspension is found suitable, the order of first review having been served beyond the period of subsequent 90 days is bad in law, which is stated on the suspension. Opposing the said submission, the CGC has submitted that he has received instruction from the mobile, specifically stating that the order first review suspension or 3 to 2023 was served on him on the same date, and accordingly he pressed some more time to file an additional affidavit to bring it on record. Prayer allowed. Respondent shall file an affidavit, additional affidavit to bring on record any stand date they intend to take in this period, specifically with regards to service of the notice of the first
have you
review.
filed the affidavit?
Yes, my lord. We will type on the same day, my lord. Through email, it was sent from Delhi to Guwahati, my lord. Accordingly, he was in Guwahati, my lord. It was started on same day, my lord. The subsequent order, my lord, extension, my lord, from the review.
So what about the first preliminary?
Yes, my lord.
Preliminary, the first round of challenge.
Yes, my lord.
This is
Yes, my
basically
lord. So far, my lord, I'm reading, my lord, the rule 10 of CCS, that rule, my lord. This speaks the order of suspension on
It's page number
page 67 in my
20 of the writ petition is that I quoted.
You have quoted?
Yes.
20. 20.
20.
Yes.
Rule 6 and 7.
6, I'm reading rule 6. In order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before the expiry of 90 days from the date of effective suspension. From the date of effective suspension, on recommendation of the review committee constitute for the purpose and pass order either extending or reviewing suspension. Subsequent review shall be made before the expiry of extended period of suspension. Extension of suspension shall not be for an period exceeding 118%, and so on. This speaks from the date of effective date of suspension. Here this judgment from referred by my friend, it was communication from the date of communication. In a Punjab case, it was suspension was this it was sent on 31st July, 31st July. And on 2nd of July, that particular person is retired, it was he received on day after, so it is the effect says from the date of communication of the suspension order. Here, we communicated suspension order of 7 of November. 7 of November, we communicate this order. Although it was passed on 1st of November, we communicated to him on 7. So our area also, as per order of this honorable court, we filed them that the effective date of suspension. So,
okay, what do you do now?
He proposed, my lord, on 7th of this coming month, my lord.
So Lordship takes it up on Thursday, coming Thursday. Very small issue otherwise.
Thursday on the 14 of my lord, 14, my lord.
Because otherwise the petitioner is otherwise suffering due to this.
It was also hard by at length by the Honorable Justice K.N. Surana, my lord. Only to submit it, whether this we have submitted and there is a record, my lord.
You have filed the affidavit, doesn't matter. We'll see.
Yes, yes, ma'am. On 14, ma'am.
14.
14.
The additional affidavit.
Yes, we already
has been filed.
We have filed a reply.
Reply
by the respondents represented by the SP which has also been replied to. by the petitioner who is presented by Bora. The parties did learned counsel for the party submit that the matter can be disposed of at the admission stage. Once para consider the forces submit and the issue involved registered is for admission on
14 September, 14/9. Tuesday.
49 is Thursday.
Thursday, Your Lordship. I'm sorry. Thursday.
But I think the law certainly is against it.
My lord, so far the date
There
of
are two
effect,
connotations. One is a dismissal order, one is suspension order. Dismissal order takes place on the date which you actually receive.
well, that order is,
Suspension, the moment it is issued, you are held to suspend.
well, that, my lord, the judgment referred by learned friend, my lord, is so far that suspension, my lord.
And there are other cases of
Many cases.
Washington thing is there, state of communication. Difference is there. Supreme Court has very lucidly explained how which date will be effective, an order of suspension vis-a-vis an order of
Dismissal, amercing judgment is settled.
at 2 o'clock we'll have the judge the question here. Each other. You are appearing in person.
Yes, yes, Lord.
Who's for the other side? So since it has been taken out of turn, I think they have been informed.
Lordship, I'll wait.
Please wait. We'll take up your matter priority basis. We'll try to have the counsel for that. The issue which is determined, which has arisen for termination before this court in this petition filed Article 226 Constitution of India pertains to our recruitment process for the post of administrative officer, which was initiated by an advertisement dated 17/12/2020 issued by the Pakistan. The case as projected by the petitioner is that he is presently working as a senior assistant as a supervisor What is the supervisory?
There is a post of supervision. After senior assistant supervisor.
Presently working in the order of supervisory assistant and was initially inducted in the service as an LDA cum typist in the year 1991. The petitioner claims that he has about 30 years of service experience without any adverse remarks. The aforesaid recruitment process for the post of administrative officer had invited application from candidates having 15 years of service in any establishment of the Deputy Commissioner in Assam, and the last date for filing the application was fixed on 18/1/2020. It is the case of the petition that though 4 candidates had initially applied for the same post, after scrutiny, only 2 candidates had remained, which included the petition and the respondent number 5. The categorical case of the petitioner is that the respondent number 5 was not eligible for consideration as he had not completed 15 years of service as on the last date of filing of the application. However, in spite of same, not only the respondent number 5 was considered, he was also appointed. He was also selected. Selected by the imputed order in 37. The petitioner has also contended that on merit, the petitioner is much above, as he was also awarded Best Employees Award on 2 consecutive years. I have heard as counsel for the petition. I have also heard the respondent who was there, government, therefore 1 and 2. And I've also heard standing council SAT, GAT for respondent was 1 and 2, and H. Chakraborty and state council for the respondent was 3 and 2. The H. Chaudhary has Chakraborty already took. We can't change him to Chakraborty. Are you agreeable? He's denying. Also heard the H. Chaudhary and council for the respondent number 5. Sarah? The Sri Goswami, the learned counsel for the petitioner, has submitted that with regard to the eligibility of the writ petition, there is no dispute that he was eligible on all respects. The learned counsel has drawn the attention of the court to the various documents to establish his eligibility, even with regard to the fact of having minimum 15 years of service. in the establishment of the deputy commissioner. By drawing the attention of this court to the advertisement dated 17/12/2020 issued by Deputy Commissioner Baksa, it is contended that one of the mandatory conditions was that the aspiring candidate must have served at least 15 years in any of the deputy commissioners established in Assam and fulfill the eligibility conditions and experience as per the Assam Ministerial District Establishment Service Certificate Amendment Rule 2009. Full stop. The General Council has referred to the graduation list which has been annexed to the writ petition, in which the date of entry of the petitioner as well as the response number 5 has been clearly stated. As per the state graduation list of grade 3 employees under the amalgamated establishment of the Deputy Commissioner Nalwari, while the date of entry of the petitioner into government service has been stated to 21/2/1991, for the response number 5, the state date is 26/2/2007. Sri Goswami, the Learned Council, accordingly submits that the state response number 5 would not complete 15 years, which is a part of the advertisement, as well as the rules governing the field. Full stop. By drawing the attention of this court to the affidavit in opposition filed by the response number 2, the Learned Council for the petitioner has submitted that from paragraph 8 of the state affidavit in opposition dated 9/12/2022, it is discernible. It is revealed that the period of 15 years has been reckoned from the date of consideration of the case when the selection board had met, that is on 29/7/2022. A similar step has also been made taken by the respondent number 3 and 4 in their affidavit in opposition dated 20th of February 2023. The Learned Council for the petitioner has submitted
that the aforesaid interpretation is not at all correct and is in conflict with the law governing it. The, if we submit that it is a settled law that an intending candidate is required to meet all the essential criteria as on the last date of filing of submission of application. As per the advertisement, comma, the last date was stipulated as 18/1/2021, on which date, comma, the respondent number 5 did not have 15 years of service period. In support of his submission, comma, the learned counsel for the petition has relied upon the following case. Pregosa, the learned counsel for the petitioner according to submission that the respondent number 5 not being eligible, comma, he could not have been considered and subsequent selected for appointment, and therefore interference called for the present. There are, by contrast, comma, 3 A. Fukan, learned counsel for the respondent numbers 1 and 2 has submitted that though 18/1/2021 was stipulated to be the last date of submission of application, the selection committee had actually considered the candidature on 29/7, by which date, comma, the experience of 15 years, the criterion of having 15 years experience was fulfilled by the number 5. The Senate Council has also referred to the rules governing the field, namely the Assam Ministerial, namely the rules of 1967. The, according to submission, that the selection has been properly done, and therefore the same cannot be interfered. The, the age of about the United States Council has also supported the 10 of the department and has also submitted that the respondent numbers 3 and 4 has filed affidavit in opposition on 20/2/2020, whereby the claim the petition has been rebutted. The A. Chaudhary, when it comes to the response for 5, has submitted that the state response number 5 has also filed an application of which on 15/2/2023. Full stop. He submits that rules prior to its amendment had contemplated that initially the expression mask was used with regard to having 15 years of service experience in the establishment of the deputy commissioner. However, the state expression mask has removed the amended code done by the amendment the year 2009. Submit that rule 8 within bracket small 1 relating to administrative officers only stipulates to have at least 15 years experience in any deputy commissioner established, which he further that since the amended rule has deleted rule does not contain the expression mask, the state requirement cannot be construed to be mandatory in nature and at best be directed. Full stop. The Chaudhary has also submitted that the stand taken by the department is a reasonable stand, as it is only on the date of consideration that the eligibility criteria are to be assessed, and therefore no case for interference is made of. Alternative, Sri Chaudhary, the learned counsel for the response of 5, has submitted that he had joined the establishment much earlier, the year 2004, though on honorary basis, and therefore the period which he had rendered service from 2004 to his substantive appointment on 26/2/2007 should also be taken into consideration. In which case, the response number 5 would meet the requirement of having 15 years of service period. The Learned Council has also A. Chakraborty further submits that in paragraph 4 of the affidavit in opposition, it has been clearly stated that as on the year on which the consideration was made, the response number 5 was on his 15th year of service, and in absence of any stipulation in the rule that such completion should be at the starting of the year, comma, the present interpretation can be construed to be a reasonable interpretation. Full stop. Aruna would put- If you can also submit that the advertisement did not mention that the eligibility criteria has to be met as on the last date of filing of the application. Sri Chaudhary, the learned counsel for response number 5, in support of his submission, has relied upon a case of the Honorable Himachal Pradesh High Court in the same case, comma, it has been laid out that the period in which an incumbent has rendered ad hoc service is taken into consideration when the same was followed by a regular service, and such consideration was for the purpose in the private submission made by the learned counsel for the part have been duly considered, and the materials put have been carefully examined. The issue, as indicated above, is with regard to the date on which the eligibility of an incumbent participating in a selection public recruitment process, public recruitment, selection of recruitment process is to reckon. In the instant case, there is no manner of doubt that as per the gradation list, the response number 5 was the date of joining in service of the response 5 was dated 26 to 2007. The advertisement in question was dated 17/12/2020, and the last date for submission of application was 18/1/2021. Therefore, by taking into consideration the date of induction, date of appointment of the petition of the S1 5 in substantive capacity, he did not complete, he did not have 15 years of experience as required under the advertisement, as well as by the rule holding bill. Under those conditions, this court is required to consider the explanation given by official respondent, which is discernible from the affidavit in opposition filed by the respondent number 2 on 9/7/2022, as well as by the respondent numbers 3 and 4 on 22/2023. Full stop. The express intent of the official response is that the requirement of experience of 15 years has been counted by taking the date of selection and not from the date of the last date of submission of the application. There is no other explanation in the affidavit in opposition. The, the state explanation, however, has been thought to be qualified by the learned counsel that the advertisement did not stipulate as to on which date the requirement of experience was to be fulfilled. The point of dispute has been settled by a number of decisions of the Supreme Court, few of which have also been relied upon by the learned counsel for the petition. So it is a set law that the eligibility of the candidate have to be judged with reference to the date, with reference to the last date of filing application. It is further been laid down. It has further been laid down that a person who acquires the prescribed qualification subsequent to such date is not required to consider. The interpretation of the official respondent given in the affidavit are in the teeth of the law holding the bill with regard to assessing of the evaluate the eligibility of candidates with respect to date on which such evaluation should be made. Those three Chaudhary, the, the learned counsel for the response number 5 in his submission has contended that the response number 5 had actually served from 2004 on ad hoc basis. That period is also required to be taken into consideration, in absence of such a stand by the official respondent in the affidavit, that point cannot be a matter of adjudication or consideration by this court, which has been raised by the beneficiary. Ultimately, it is the decision-making process by the respondent which is subject matter of adjudication, and it is a right law that reasons which are discernible from the order are only to be examined by a court of law adjudicated, that is true. In the instant case, the only stand taken by the official respondent in their affidavit of petition is that the date of consideration has been treated to be the date for assessing the eligibility criteria, which is not a correct position of law. This court has also considered the submission of the Chaudhary regarding omission of the expression mass in the amended rule. However, the a reading of the rule makes it clear that a candidate is required to have service of at least 15 years, and there cannot any that such expression is to be treated as mandatory. This court is also of the view that if such eligibility criteria are determined on date of actual consideration, it would be an unending process. And as in the meantime, many more would acquire the eligibility and would make a stake for such a person, which would not be a reasonable interpretation at all. In view of the efforts and facts and circumstances, this court is of the unhesitated opinion that a case for is made up according to the selection, the consideration, selection and selection of the respondent of 5 in the selection process initiated by the advertisement dated 17/12/2020 for the post of administrative officer under the establishment of the deputy commissioner doctor is whereby the respondent of 5 has been selected in appointment is set aside according to the respondent authority are directly considered the case of the petition and take steps for appointment in accordance with law. The aforesaid process, which is directly carried out above, is to be completed within a period of 2 months from petition accordingly is allowed.
All right. Okay, 3 months of service, 1 month. Within 1 month, 3 months of service only.
Oh, you've got 3 months.
3 months.
Okay. That are good. At this stage, the Goswami, the learned counsel for the petitioner, submits that the petitioner is to retire
on December.
Has hardly is to retire in December 2023. Considering the above, the aforesaid exercise be completed within a period of 45 days from today.
All right. Obliged.
So, what is this? Personal petition is appearing in person.
Well, he has been pursuing my lord since the filing of the writ petition.
Doesn't matter. What is
Otherwise, my lord, we are supposed to make certain payments. To my information, my lord, we have complied with the order, we have paid everything. Only last, my lord, the amount remains is regarding the non-practicing allowance. He was a professor in, my lord, AMCH, retired now. That, my lord, we have already forwarded to the accountant general. That was the last thing.
Have you received the earlier payment?
The area pay, Lordship, in the area pay, last time I had pointed out that a particular 13 months period has been excluded for unexplained reason. This is the pay bill submitted by the authorities to the treasury and from to the bank. So according to this,
13 months, 13 months have not been paid.
13 months not
Why?
That part, my lord, he has been pleading before his honorable court in the contempt case. If he submits some representation before the authority, because that.
No, see, we may not be too technical. Since the issue is
then, my lord, let him file one short affidavit. I will
not required. We'll have this recorded in the order.
Done.
You take instructions on that. We want to close it. And since you have already submitted,
yes,
that substantial payment has been made, and the last non-dual for
non-practicing allowance
has already been set to the AG.
AG, my lord.
We'll fix this matter maybe after a month, and you also take instructions
Regarding
on
that
this
claim.
aspect of 13 months.
Is it,
Do you have a chart or something?
Yes, Lordship.
Which month?
It is there. This is
Which month? Which month?
From July 1997 to July 1998, 13 months. This is the bill submitted by the authority, and this period is missing in that. So I have not received the pay to the concerned period.
Dr. Basanta Laskar, petitioner in person. Also heard P. Gogoi, Senate Council for order respondent.
Yes, sir.
P. Gogoi, the Learned Council, however, submit that the order in question has been substantially complied with, and only with regard to the non-practicing allowance,
Yes,
the amount is to be released, and that matter has also been forwarded to the Office of Accountant General.
on 28/6/2023.
28 or 20.
No, 28.
28/6/2023, and the response is awaited. However, Dr. Laskar, the petitioner in person has submitted that in the bill submitted, and in the payments made, there is shortfall of payment for 13 months.
13 months.
From the month of July 1997 to July 1998. Para. Sri Gogoi, the Learned Council for the respondent, is directed to obtain instruction on this aspect and apprise this court regarding steps taken on the next date. Let us fix the date since you are in person. Tell us the date of your convenience. You come from Dibrugarh, or you
I come from Dibrugarh also.
You tell us the date of your convenience.
After what?
After a month.
The same day today, same day as today.
No, give a date so that you can come. We'll fix the date.
6th of October. 6th of October.
6th October is okay for you?
1 month will be okay. It will be okay.
As agreed to by the party, based on 6th of October. Try to finish the matter on 6th. And you get the instructions from AGL.
Yes. After that instruction, I will have.
Last time, Mr. Chalia had promised to look into that matter. I thought that today it will be cleansed.
Now it's not in the hand, my lord. But this new claim, my lord, I will have the instruction. You have to verify.
Gogo will not break the promise. Gogo will not break the promise. Hopefully. Yes.
My lord will kindly have a look at the last order, whereby, my lord, at 21/7/23. First para, K. Gogoi, Learned Standing Council Higher Education has produced a letter dated 27/23 along with budget allotment to Dibrugarh University for an amount of rupees 18 crore. The letter dated indicates.
Amount has been released or not?
No, my lord.
Why?
Lordship, the sanction has not come to the year, Lordship. Financial thing has not come to the treasury. So it's not their amount has been sanctioned, but it has not been released. There's no instruction for release. In this connection, Lordship, the university had written twice, Lordship, on 2/8 and 11/8. I've given copies to them.
I have received one copy letter from the Dibrugarh University from my senior brother. Lordship. I have to obtain instruction regarding this letter.
No, why is this impasse?
For a pretty long time, my
Lordship.
Complete this. You have sanctioned the amount.
Lordship.
What kind of
otherwise, Lordship, fund is not there, so Lordship, from the contingency fund it was given, Lordship.
Take some proactive step because these are matters pending is long.
My lord, judgment is of 2021.
See, it is not a case that we are spring over the matter, Lordship. We are trying to solve the issue, Lordship. Otherwise,
we are not doubting your attempt to solve, but it takes some more proactive step.
Even
You want to push it, complete it.
I will do, Lordship. Otherwise,
my learned friend can have the instruction on Friday, my lord.
I will do Lordship. I will
Next Friday.
Lordship. Otherwise, also Lordship, some difficulties is there. I will do everything.
So see, those difficulties otherwise,
Difficulties.
those have been taken care of. Now
Difficulties.
we'll not go back into difficult. Now,
Difficulties on the part is that Lordship, all the new incumbent is come. Yesterday, one director is joined Lordship, and secretary is also additional.
okay, that
secretary also
difficulty.
joined
Okay,
Lordship.
that difficulty you have to take
Lordship.
care. Next Thursday, next Friday. Third weekend.
Hopefully by that time, my lord, I mean, they will.
At least come up with some concrete instructions. That
Yes.
it has reached-
I'll do.
it has reached this place now. This
I'll do. I'll bring it, Lordship. I will bring it.
heard speaker to Senior Council assisted by Sri DJ Das for the petitioner. Also heard Sri K. Gogoi for whom?
My learned friend, respondent number 1.
K. Gogoi for 1. For respondent number 1 and Mr. Goswami for R. Goswami for respondent number 2. Put up. Para. The Senior Council for the petition has referred to the earlier order of this court dated 21/7/2023, in which it has been recorded that as per the submission of Sri Gogoi, the university has been afforded its budget allocation of rupees 18 crore, which has been allocated by the government of Assam in the education with higher department for contingency fund for payment of pension, public family pension to the eligible pensioners of the Disciplinary University in terms of order passed by this court. It is, however, submitted that till date no amount has been released. The Gogoi Learned Council, however, submitted that due to some administrative change, he could not have the immediate instructions and praised for some time and assured that the matter would be settled since the amount has already been allocated. Please on right.
8, 9.
So as to enable the Learned Council to have the instructions. Yes.
Here we have received some instructional order.
We have not filed the affidavit.
No, we have not filed. We have just received the instructional order.
Will you file the affidavit? What is the issue?
That relates to initially the petitioner was engaged against a particular SCDS project. Subsequently, the village has been bifurcated to two different SCDS.
You are an Anganwadi worker.
Yes, ma'am. Helper, madam.
Helper.
Helper.
Thereafter,
now, same revenue village falls under two different SCDS projects. I was initially appointed against the Ujuni Majuli SCDS project. Now I have fallen under Majuli SCDS project. Post of Anganwadi worker has fallen vacant under Ujuni Majuli SCDS project. Here I have not been allowed to participate for promotion. There is a promotional criteria for promotion of
from helper to worker.
That is why the petitioner is before lordship.
So because of
Bifurcation.
denied the chance to get your upgrade.
So the notification says
Same village, but two ICTS project in the same village.
Same
village. So now she is in the other ICTS project. The vacancy is in the
other
next
ICTS project.
Are there any private response?
No, my lord.
You file. Or it the year. Then it comes to the petition, whereas it respondent respondent are represented by three as The other considered from third state of accepted that drug habit and to take by an affidavit. 3 weeks as it is of the available highly such affidavit.
My lord, I am on humble prayer. I think 43 mile. It is a review petition. In this case, you are lost to dispute the review petition on the ground that I have no feasibility certificate. But after filing the review petition and before dismissal of the case, feasibility report was given. So if that order goes, my salary would be stopped. So I have maximum margin. I have annexed those feasibility report.
We don't know what is the matter about it.
So 43 that. So I think 33 Malad, I am paying for time Malad. They have filed the affidavit in opposition. That is 33. I will file this time Malad.
33.
Malad.
I think Facebook and it's granted 3 weeks time to file return directive. Mr. Gupta is there. 33.
Mr. Gupta is there.
3 weeks to him file the affidavit.
We have filed the affidavit actually.
They have filed. I have
No, rejoined it.
We have already joined it.
So Mahmood, today it may not be possible. What is it we have not followed?
That means he is the subject is a teacher of history in Banmukh Higher Secondary School in the district of Shivsagar. Now we filed.
We have delivered the judgment.
Yes, that was dismissed on the ground of there is no feasibility.
Correct.
But when the requisition was filed, there was no feasibility, but my post was provincial. Your lawsuit dismissed the requisition on the ground that there is no feasibility report from council. Now, in between, council has granted this feasibility report in favor of the petitioner of the subject history.
Why didn't you bring it to the notice?
No, after dismissal, it came to my notice the party. So we have brought that review only simple matter. Report is there. So if your lawsuit order goes to the office, then my salary would be stopped. That is why summons is. It is matter of 43.
We'll have it tomorrow, day after.
Day after tomorrow.
Day after.
I will permitted to mention if.
Okay, let us. Day after tomorrow, today we have to raise RT because of the time. Otherwise, it would have easily done. Yes, next.
Problem.
Who is on the other side?
Secondary distance.
Secondary.
I say it council.
Huh? High secondary.
Council is the main part.
You have judgment for.
Yes.
This case, your lordship, earlier notice was issued, your lordship. They were directed to produce record. Probably they have received, your lordship, may fix the date, your lordship, for disclosure. Today probably it will not be possible.
What is the subject matter?
Subject matter, your lordship, in a disciplinary proceeding, your lordship. After your lordship, the inquiry was conducted, your lordship. Inquiry report was submitted, your lordship. Penalty was proposed. I represented against them. Suddenly, your lordship, further inquiry was given, your lordship. That part I have selected. Punishment proposed, your lordship. I submitted my representation against the proposed punishment.
What was the proposed penalty?
Dismissal.
Okay.
Then your
why further inquiry?
That we don't know.
Mr. Ratta, you file affidavit?
Yes,
Affidavit has
no,
not-
my lord, the last occasion, my lord, this is
So it was only notice was issued.
Notice was issued.
You have the instructions?
Huh?
Have you got the instructions?
Yes, my lord.
You like to file your affidavit?
Yes, my lord.
How much time?
2 weeks, my
Let them file.
my lord, it is.
2 weeks. We granted 3 weeks time. File.
No, my lord.
2 weeks.
Let
Are
him-
you sure you'll be able to file in 2 weeks?
Yes, sir. Within 2 weeks.
Very good. Okay. Third. Real Kota for the petition. Oh, there's an interim order.
Lord.
That is why 2 weeks.
My lord,
Let them file.
last occasion, my lord, this honorable court directed me to produce some documents, my lord. But
You
notice
filed
was
the
not-
affidavit, we will consider because it was at the motion stage last time.
Yes, my notice was not
Court
issued.
could learn counsel for the petitioner. Para 3.A dot learn CGC appearing for the respondent submit that instructions have been received.
Yes.
And an affidavit would be filed for which he has paid for 2 weeks. List after 2 weeks. We'll fix the date.
Your Lordship has fixed the date.
Tell us the date of your conviction. List on
After 20, your Lordship.
page 29 or 30. 2 weeks. On 18th.
Lordship.
18th.
My lord,
Interim order passed earlier to continue.
my lord, one is not notice was not issued upon the IO, my lord. I cannot appear against IO, my lord.
Inquiry officer.
Not the case. Correct.
Deputy Mayor inquiry, my lord.
A notice was issued. Steps regarding steps, we have not said anything. Mr. Bortakut,
Lordship.
we have not said anything about the steps to be taken. Otherwise, notice was issued. It is
Or
not-
your Lordship.
it is not restricted to any particular respondent.
Lordship. Respondent
No,
number.
no, and it is further been stated that Dutta appears for all the respondents.
Lordship, that's why your Lordship.
You cannot appear for IO.
Yes, IO, I cannot, my lord.
IO is by name.
No, not by name.
Then
my lord.
why
He
not?
can, your
The
Lordship, only
independent body,
record.
I think,
Why independent body? If it's by name, then only matter will be different. IO is not under you. Which is the IO?
Respondent number 4, your Lordship.
Deputy Medical Superintendent.
Lord.
He is by means of being a Deputy Medical Superintendent, he is the IO. Act officio. You can
my lord, after 18, my lord.
tell us. We have asked your choice.
18,
When are you? 20 to 0.
22nd, your Lordship.
Why?
No, 20, your Lordship, I may not be available.
22nd is it okay, Mr. Ratta? 22nd. 20.
Interim order shall continue till.
We have
Deeply obliged.
not here. Yes, who's there? B. Pathak. B. Hazarika. You are there?
My lord.
File your affidavit.
Not, we are awaiting instructions, my lord.
We will not record their absence. We'll say that you said.
My lord, my lord.
The Gupta, H. Gupta, learned this is praise for and is granted 3 weeks time to obtain less file affidavit.
My lord.
Please, Your Lordship. Lordship, in this matter, we have not received the extra copy.
Which petition?
Both.
Fourth.
You give extra copies, we'll have it. You take instructions then. Learned counsel for the APS as well as the state council submit that extra copy have not served. Whereas CF learned counsel for the petitioners in these cases undertake to serve extra copy by tomorrow. But just after
No, my lord, date may kindly be fixed because the result is, her result is withheld, my lord.
please on
7th of September, my lord.
Not 7.
next week. We'll have it on 18th of September.
My lord.
18th September.
Okay.
Come up with instructions. Give copies tomorrow.
Obliged.
Obliged.
Okay, your lordship, we are filing it today, the affidavit. I actually could not locate the number of the petitioner's advocate to serve upon. So we'll file it
You
during the
can
course of the
you
day.
can serve him. D. Bora, Leonard, you are acting as the government.
Yes, sir. 1, 2, 3.
State Council submits that the affidavit in opposition of state respondent is ready and it be filed within a day or just after a week, allowing capital that may be filed. Madam, you have for
Respondent number 5.
you filed affidavit.
No, Lord.
You filed.
Lord, of the fact, Lordship. They are already. I am holding the post first.
There is an interim order.
No, Lord.
No, Lordship, actually, it is a totally violation of the advertisement law and notification also. Lord.
Will occur.
Applies.
I mean 56, the sewerage board matter where they are not getting salaries after the transfer of the scheme to this.
Yes,
My lord, before my learned friend start, I have a feedback on behalf of my client. I need just 1 week time, my lord, to file my affidavit. Because ultimately I have to pay, and what is my my lord, financial position that I will express.
But in the meantime, let them pay
If
some
you
amount.
remember what Mr. Nayak has projected last time and even the data also.
My lord,
You have your own scheme for.
Yes, that affidavit I have already filed.
You have filed affidavit.
I have given all those records.
You are
My
not
lord,
receiving the salaries.
in order to give a precise order, my lord, my affidavit will help you, lord, because ultimately I will have to pay. Therefore, my lord, these facts should be before.
Have you written to the government if you want any assistance? Of,
Yes,
it is a different matter that your scheme is a self generating income scheme.
My lord, we have
But if
intimated
you have done one tranche,
my lord,
you have to explain how much you have received, how much have gone, then you have the fund tranche.
I have.
The government will not be.
Even for this, for the purpose of this scheme, the fiscal court is maintaining a separate bank account.
My lord, if your lordship,
See, as of the London Senior Council, appearing for the Filter Municipal Court,
my
submit that instructions have been received and praise for time to file the affidavit.
Let it be on Thursday next, my lord.
We asked the London Senior Council for the petitioners, however, expressed urge, as salaries have been held up. So, as agreed to by the parties, list on
Next Thursday, my lord.
next Friday.
Friday.
Friday means my lord, this Friday.
No, not today after tomorrow.
Yes.
Next Friday.
Yes.
1 week.
That's all.
I have filed back.
Is it on record? The affidavit filed by the Finance Department.
No, it's by the Department of Housing and Urban.
The affidavit of the Department of Housing and Urban may be tagged along with the record. Rest date.
In this case, my lord. My lord.
You take your breath, not
No,
today,
no.
tomorrow.
My lord, interim order shall be continued, my
Which
lord.
one?
55, 57.
55 and 57.
We have already
There is an interim order till
we
today.
have already discontinued the interim order, vacated.
No, my lord.
You are not here.
No, man, I was in code number 2, my lord.
We do not know. Whether you are in code number 2 or having coffee, we do not. Interim order,
That is why I am running. 55 and 57.
if any. Yes. Any interim order.
Item 59.
No, no, Muthu Bele case. Oh, yes, yes.
59. 59.
No, no, 55 and 57. Mine is Danu.
59.
Highly obliged.
50 to 59 series, can it be on the 13th of September, Lordship? That
ACC matter. Yes, madam.
13th of September.
Lordship.
13th
Convenient to the Lordship.
And in that you write interim order if any is extended. You are in the ACC matter.
Yes, Lord.
My lord, may fix the matter last week of September matter.
13th or 15th, Lordship. Yes,
Last week of September.
Last
people are without job, Lordship, for a long time.
21st of September is good.
13th of September is
13th of September, Lordship.
Like.
All right.